My lord, I'm praying
kindly to mention.
No, leave me, lord.
So I didn't know one.
No upgradation, please.
No, my situation is very different.
Even then.
My lord, may I just mention, my lord?
No, Mr. Banerjee.
My lord, ours is formation of a division bench by your lordship.
I know that has been mentioned yesterday. I'm taking steps. I've assured you, learned friend. So don't insist again and again and again.
No, my
Please don't do that.
Dip you.
Yes, it item 1.
No.
What is the correction? What is the correction? Who has mentioned?
Lordship, perhaps the matter has been come in the instance of my learned seniors on behalf of the writ petitioners, Lordship.
The matter has been mentioned for correction.
Yes, your lordship. Lordship, I appear in this matter, your lordship. I had requested for correction. Your lordship, actually, my name is not appearing in the list.
The matter has been
even
mentioned for correction of the order dated April 18, 2024 for the entirely frivolous reason that the names
No,
of
your
advocates appearing in the matter has not been recorded. First up, let the matter go out of the list with a request to the advocates not to mention matters.
Your lordship, the
of
name has
opposition
not
in the list
appeared in
for
the
such
judgment.
flimsy reasons. Next.
My lord. Deep request.
Item number 2.
Yes.
Lordship, this is appearing at my instance, your lordship.
Yes, please. What is
This
the
was
matter?
the writ petition which was taken up on 27th of March.
Right.
And your lordship recall, this was a challenge to the RBI circular where I was supposed to close down my business. Now, pursuant to the lordship's order,
Yes.
the RBI has resolved the issue. And they have effectively allowed us to operate, and they have given that window in terms of the circular. Hence, our client has given a formal instruction to withdraw.
Right.
My lord, I am appearing for Reserve Bank.
Right. Learned counsel for the petitioner submits that the cause of action of the writ petition has been rendered infructuous in view of the relief sought by the petitioner having already been afforded to the petitioner. First up, accordingly, the petitioner seeks to withdraw the matter. First up, a written instruction in that regard filed in court today be kept on record. In terms of the prayer of the petitioner, WPS 6048 of 2024 is disposed of as withdrawn without an order as to cost.
Great.
Yes. Right. Next. Next. Dako.
Upgrade motion item number 3.
My application.
For it to ready, Dako. Yes, Mr. Ganesh.
My lord, by an order of 1st of April 2024,
Right.
lordship had passed an interim order directing them, giving them time to file their affidavit in opposition. My reply, we were supposed to come back. The opposition I have received yesterday. It gives me 7 days time to file a reply to this. We can come back.
It is submitted, but you are filing the opposition today?
Yes.
The affidavit in opposition filed today be kept on record. First of learned counsel for the
number 2.
Acha. The affidavit in opposition filed today on behalf of respondent number 2 be kept on record. Learned counsel for the petitioner seeks an extension of time for filing reply since the copy of the opposition has been served yesterday. First up, accordingly, the time for filing reply is extended for a week from date. First up, the matter be listed for hearing on May 1, 2024.
Lord, my interim
The interim order granted earlier is extended till June 15, 2024 or until further order, whichever is earlier.
Grateful to you.
Next. এটা কিন্তু রেগুলার হেডিং আসবে।
Item number 4.
Yes.
For the petitioner,
Yes, please.
this is the affidavit of service
Right. All have been served.
served
Yes.
through email, my lord.
Paper for the private respondents,
Right.
number 6 and 7.
You for the state.
My lord, pursuant, lordship may kindly take up page
But before it
20.
begins, Lord, there is one thing I should mention, Lord. This was mentioned without notice.
this is
Yeah, I've been
Why
taken
to
by
mention
surprise
without?
today.
my lord,
I've been taken by surprise today anyway. I've not said
this is
it,
the
Lord.
notice, and the on the reverse is the email.
Yes, what is the matter? Page 20.
My lord, page 20, my lord, the in crux, my lord, the petitioner's gift deed, which was gifted with regard to a property by his father, was cancelled in terms of the provisions of section 23 of the Senior Citizens Act. Now, my lord, this is my father's application in page 20. The application was heard. Lordship will find the order in page P1, page 20, page 16. The maintenance tribunal cancelled the deed of gift, although it is not a conditional gift. The gift deed I have enclosed. This lordship knows, well, they have I'm protected by the division bench or order of this honorable court as well as the apex court until and unless it is
Sir,
conditional.
please place the order first.
My lord,
This is 14th of March.
my lord.
Yes, please place it. You can start from
I-
petition transfer.
I will take your lordship straight away to page 19, the ordering portion on from top.
Acha, very well. Yes, yes, please.
My lord, Section 23 of the Maintenance and Welfare of Parents and Citizens Act of 2000 provides for the transfer of property to be void in certain circumstances, which includes two essential preconditions to it. First, the document should have been executed after the act came into force, and second, failure on part of the transferee to provide such amenities and physical needs as
ওখানে একটা
mentioned in
মামলা
as mentioned in the property transfer document to the transferor. This is very vital, my lord. Considered, the maintenance tribunal is hereby pleased to pass an order to the effect that the said gift deed made between the two parties on 3rd day of December 2021 in respect of the property of Bastu land measuring so and so, pond measuring so and so. My lord, may kindly skip over to the bottom portion, being deed number 1628744 for the year 2021 in the said office is declared void in terms of section 23 of the Welfare and Maintenance of Parents and Senior Citizens Act 2007. Officer
What
in
is
charge-
this? You have challenged this here.
I have challenged this.
What is this? How do you defend this?
My lord, there is another writ petition pending. Here, my lord, the issue is completely
I'll
different.
set it
my lord.
aside at the drop of a hat. There is no
Will-
reason whatsoever.
Will
What
kindly
is
allow-
this?
will
A
kindly
travesty of justice.
I understand. I understand, not even I've read the.
No, no,
gift deed.
I'll remand it back. Definitely you have a right of
Gone through the-
hearing.
I've gone through the gift deed as well. My lord, I am residing in the property. That is my property
Whatever,
from where I have been.
whatever.
My lord,
I
there
cannot
was
go into
another
the
writ petition.
facts.
I had, my lord, there's
No, the
another,
tribunal has not gone into the facts. Why should I?
my lord, there was another writ
Well,
petition.
it
Lord,
is a
will kindly
settled law that until and
What another writ petition?
another
By
writ petition
whom?
was moved by me before this honorable court, my lord, where the directions are passed directing them to allow me to enter into the premises.
Maybe.
Beside-
That has no nexus with
Lord, will
this.
kindly allow me to
it
use
is
the
a settled
affidavit.
law that until and
No,
unless
no
the
question
deed
of any
contains a specific clause with regard to it's a conditional deed, it cannot be set aside.
Lord, kindly take up the deed of gift also.
I won't look into it because the court has not. Learned counsel
may-
for the petitioner contends that the petitioner is the son, you are the son or daughter?
Son.
The son of the private respondent, full stop. A gift deed was executed by the private respondent father in respect of the petitioner. Full stop. The petitioner has assailed an order passed under section 23 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007, which is utterly devoid of reasons. First up, it is contended that without consideration of any of the yardsticks stipulated in the act or the facts of the case, comma, the tribunal has cancelled the deed of gift. Declared the deed of gift void. First up, next para, learned counsel appearing for the private respondent contends that the gift deed itself will justify the case of the private respondent. First of that apart, comma, the private respondent has taken out a different writ petition for a direction, or a direction has been passed,
Direction has been passed.
where a direction has been passed directing possession of the property to be given to the private respondent. First up, next para, a perusal of the impugned order justifies the claim of the petitioner that the same is utterly devoid of reason. Full stop. Reason is the spirit of any order. Full stop. The impugned order, comma, passed by a quasi-judicial authority having serious implications, comma, taking away the rights of a person conferred by a registered deed, comma, has to be taken on a serious note. Full stop. Despite repeated perusal of the impugned order, comma, I fail to observe that a single line of reasoning has been attributed for declaring the gift deed in question to be void. Push up next para. Section 23 of the 2007 Act stipulates that where any senior citizen after the commencement of the act has transferred by way of gift or otherwise his property, comma, subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferee refuses or fails to provide such amenities and physical needs, comma, the said transfer of property shall be deemed to have been made by fraud or coercion or under undue influence, and shall at the option of the transferor be declared void by the tribunal. Push up in the present case, comma, the gift deed itself has not been considered by the tribunal at all. Push up, there is no reflection in the impugned order either that the tribunal adverted to whether there was a condition, the transfer was on condition that the transferee shall provide the basic amenities and physical needs to the transferor, and as to whether the transferee actually refused to provide such amenities and physical needs. Full stop. In the absence of any consideration of the yardstick stipulated in section 23 and or to the factual premise of the case, comma, the impugned order is palpably vitiated in law. Full stop. Accordingly, WPA 95, আচ্ছা আরেকটা line add করে দাও। The contention of the private respondent that in a different writ petition, comma, a direction has been passed by a coordinate bench for handing over possession of the property to the private respondent lies neither here nor there, full stop. The said direction, comma, if any, comma, does not per se justify the order impugned herein, comma, which had to satisfy the parameters as stipulated in the 2007 Act. Full stop. In the next para, in view of the above observations, WPA 9550 of 2023 is allowed on contest, comma, thereby setting aside the order dated March 14, 2023, passed in Maintenance Tribunal case number 01/23 by the Subdivisional Officer and Tribunal Officer, Maintenance Tribunal, Canning, comma, South 24 Parganas, and directing the said tribunal to rehear both parties and uh, adjudicate the application of the private respondent under section 23 of the 2007 Act afresh in accordance with law and adverting to the facts of the case as well as the legal yardsticks stipulated in the 2007 Act. Full stop. It is expected that such re-adjudication shall be concluded at the earliest, comma, positively within 2 months from the date of communication of this order to the said tribunal. Full stop. No orders to cause administrative.
Keep down. My lord, at the top, lordship has mentioned that the petitioner is the son of the private respondent number 6.
Acha, private response.
6 and 7.
6 and 7,
Six
both
and
both
seven.
parents.
Yes, parents, father and mother.
Very well. Private respondent number 6 and 7. So you're not the son of your mother. No, only father has filed this. That
The application was filed by the father.
anyway, you're son of both.
Son of both. Admitted.
Next.
Item number 5.
Yes.
I'm for the petition.
Yes, please. What is the matter?
Regarding my submersible pump under section 56(2).
Sir Ghosh, what about service? Please file your
Sir,
affidavit of service.
Junior has shot, but I junior.
It has to go out of the list. Sorry. The petitioner is not prepared with affidavit of service. Accordingly, let the matter be adjourned for the day and be listed now under the regular heading. Next.
Under the heading.
Regular heading now. Yes, next.
I saw undertaking. given-
Item number 6.
Yes.
6 Mala, I'm for the petitioner.
What is the matter?
Mala matter
I'm
relates
for
to
the-
Mala the petitioner is a consumer Mala install a submersible pump. Mala the regularly bill Mala was raised Mala and petitioner go on paying. Subsequently Mala in all on a sudden Mala the huge amount of bill Mala has a Mala raised for few days only Mala. Kindly have a look Mala page 22 of the instant deed application where which will reflect Mala the observant Mala claim. Mala, my lord, have got it, Mala, page 22.
Yes.
Mala, page 22, kindly have Mala right hand side corner top. Mala, previous reading date and present reading date. Previous reading date is Mala 12th August to 2021, Mala.
Yes.
Is just that Mala bottom, Mala present reading date, Mala 6th September. Mala, there is a difference, Mala, in between Mala previous reading date and present reading date is Mala 25 days only. Mala, then Mala, kindly have Mala first, my lord, the second paragraph, my lord, the underline within my lord, the previous reading and present reading, my lord. My lord, on that page, my lord, the
Yes.
the 25 days, my lord, they are claiming, my lord, I have consumed my lord 22,942 my lord units by 25 days. My lord, it should be my lord accumulated unit. My lord, after my lord receiving this, my lord, the bill, my lord, I raised objection. My lord, then my lord, that was my lord heard by the RGRO. My lord, that is at my lord at page my lord. There my lord, it is admitted. My lord, page 29 is the my lord order passed by the RGRO. My lord, the last third paragraph from bottom, my lord. However, it is in this instant case, the AE and station manager Gokorno Customer Care Center has authenticated the bill of a bill. Next para, sorry, my lord. But But on the contrary, this was a mishap on the part of the AE and station manager Gokarno, that accumulation of reading. And this is the point, the accumulation, it's the accumulation of unit, which
Ombudsman refused on the ground of limitation.
yes, my lord, the order passed, kindly have a look, when the order when
30.
20 page 28, 23rd November 2022, orders signed by the on that day, I shall not receive. If I receive this on 25th May, 25th November, then within the stipulated period, 20 working days. In the
What is the stipulated period? 30 days?
20 days, 20 working days. 20 working days.
Yes, Mr. Kole, 20 working days cannot come on 23rd of December.
My lord,
In the identical
I am not on that. If ombudsman had or not, my lord, I am not. I am not. Your lordships kindly consider the order passed by the Milot
RGR,
RGR.
I saw that.
Well, it's a well considered order.
Well considered, but without considering
given-
what is the period of that bill, whether 56(2) applies.
No, my lord, this is accumulation of unit. There is no, my lord, there is no,
Ground given, Mr. Kole,
my lord,
in
it's
the
accumulation of unit. Because the
faulty meter reading.
no, yes, non-taking of proper meter reading.
So when
Yes,
did
then-
that happen? For which period?
No,
Not
no.
disclosed in your bill.
That my lord, we can disclose.
Unless you disclose, how do you know it is
Because
not barred by 56(2)?
No,
Yes,
no, my lord, it's a regular, it's a my lord, continuous shown as recoverable because it's a meter.
Well, I'll direct the ombudsman for the time being
It's
to.
a meter reading.
I'll set aside the order of the ombudsman, direct the ombudsman to consider the challenge on merits.
So that I have not. I have not.
identical matter,
But-
Mr. Kole was
But the Milot grievance. No, no,
the-
Keep it with you.
PPC
With the order.
the
Aरे,
my lords have
কথা
passed
বুঝি
the
না।
order,
my lord, 56 cannot apply. Your lordship.
Yes, I did-
Why do you say that?
Because it's a my lord, 56 provided
Continuously shown.
continuously shown as recoverable because meter is
Has that been considered by the RGR?
yes, my lord, it's accumulation of unit. RGR has considered.
Show me that.
Well, it is.
Anyway, I'll put
My
it
lord,
there.
but on the contrary, this was a mishap on the part of the AE and station manager Gokarno CCC that the accumulation of reading should have
When-
been
from
occurred
when
due
date,
to
Baba? Which
non-taking
date?
of proper meter reading.
Yes, accumulation of reading, but whether it was continuously shown for what period,
Well,
Mr.
it's a
Kole,
meter.
nothing.
It's a meter. Meter accumulation. Meter reading was accumulated due to non-taking of proper meter reading. That is why, my lord, the accumulated.
Accumulated for how much time?
Well, it's after 2021, he has paid last bill.
The
no, it's
present
it's
challenge
not-
has been preferred against an order passed by the ombudsman,
it's not
rejecting the
accusation of-
petitioner's challenge against an order passed by the regional grievance redressal officer only on the ground of limitation. Full-stop Learned Counsel for the petitioner points out that the order of the RGRO was signed and communicated to the petitioner only on November 23, 2022. Full-stop the limitation, it is submitted, is 20 days, 20 working days from the date of the order. Full-stop. Next para. The application was presented before the ombudsman on December 23, 2022, and as such, the same was not time barred. Full-stop. Heard Learned Counsel for the parties. Full-stop. Although Learned Counsel for the WPACDCL seeks to support the order of the RGRO on merits, it is beyond the scope and will be premature for this writ court to enter into the merits in view of the order proposed. Full-stop. Next para. In view of the order having been signed by the RGRO on November 23, 2022 only, it is evident that the application was presented before the ombudsman within time. Full-stop. In fact, even if there was a marginal delay, the ombudsman ought to have given an opportunity to the petitioner to explain the delay and decide on such issue. Full-stop. Be that as it may, instead of wasting further time in directing the ombudsman to consider whether there was any delay, even if there was any such minuscule delay, the better course for both the parties would be to direct the ombudsman to re-adjudicate the issue on merits and come to a finding as early as possible. Full-stop. Accordingly, WPA 23824 of 2023 is disposed of by setting aside the impugned rejection of the ombudsman dated January 3, 2023 and directing the ombudsman to rehear the challenge preferred by the petitioner against the order of the RGRO on merits in accordance with law upon affording opportunity of hearing to all concerned, preferably within 2 months from the date of communication of this order to the ombudsman. Full-stop. Disconnected.
No, not it. Well,
There shall not be any disconnection of the electricity supply on the ground of non-payment of the disputed amount till adjudication of the matter by the ombudsman, full stop, the above ad hoc restraint shall be subject to the outcome of the ombudsman's consideration. Full stop, it is made clear, comma, however, comma, that nothing in this order shall preclude the WBSCDCL from taking appropriate steps in accordance with law in the event the current bills, comma, minus the outstanding disputed amount, comma, are not paid by the petitioner in the meantime. No orders to cause suggested. Thank you, sir.
Grateful to you.
These are small matters can be resolved
Yes, yes.
probably. Yes.
No, I am not raising.
You
it.
only have to show Mr. Kole before the
Yes, yes.
ombudsman. Take care that this time the ombudsman considers those things.
Yes, yes, yes. But Milord, one thing, Milord, this is really, Milord, the RGRO's order I have never seen. This is the first time.
Very well listened.
It's a very
You
well
are absolutely right and very well written.
এবং sympathetic order.
Absolutely true. Yes, next.
Number 7.
7, same thing, my lord, limitation ground.
Like the identical matter, man.
How many
My
such
lord,
matters, Mr. Chaudhary?
In Mushi,
Any other matter after this?
in that area, total,
Today, no, only
The other-
in that area, total 138 petitioner will come.
All to Mr. Chaudhary?
no.
90%.
Give an ad, give an ad.
10%.
But it should not look like an ad because otherwise he'll be, bar council will may call you then. Very well. Same order then, what is
Yes,
the difficulty?
yes, same.
No difference in fact. Very well. Same.
নামটা চেঞ্জ হবে কিন্তু।
Names will be different and number will be different. Yes.
Item number 8.
8.
I am for the petition.
Madam,
Pursuant to your lordship direction, my lord, the
kindly
inspection
your
was
lordship
held-
last order.
inspection was held and my lord, assessed the cost of amount for shifting charge, my lord.
If they paid this amount, my lord, we will shift.
You will spend the amount?
My
Very
lord,
well.
no,
So what was the difficulty? I mean,
So what happened previously?
just in a nutshell, Mr. Mukherjee.
His grievance is that, my lord, that the WBACDCL has installed a, my lord, transformer in front of his land. Therefore, my lord, he cannot, my lord, ingress has been, my lord, affected. For that reason, my lord, he
Wants
asked for
removal.
shifting. Now,
You have raised the charges. It's possible. He wants to.
yes,
Very
that is the report.
Learned counsel for the WBSCDCL, you are filing this today?
Yes. That is
Files-
direction to file.
Files communication indicating the costs for shifting of the high tension transformer from the vicinity of the petitioner's land. Full stop, next para, it is submitted by the WBSCDCL that it is feasible to so shift, comma, subject to the petitioner paying the said amount. Full stop, learned counsel for the petitioner on instruction submits that the petitioner is agreeable to pay the amount. Full stop, accordingly, WPA 2842/9 of 2020 is disposed of by directing the petitioner to pay the amount of rupees 111179 as costs for shifting of the transformer from its present location. Full stop. Next para, upon payment of such costs, comma, the WBACDCL shall remove the transformer to the alternative location located by the WBACDCL, comma, positively within
Kindly give it 4 weeks, my lord.
4 weeks from the date of such payment. No orders to cause urgent certificate copies. The communication filed in court today be kept on.
Great.
Next.
Item number 9.
Yes. In this
Milord, I am for
similar
this.
matter, but
No, it is not similar, Milord. The ombudsman passed a draft settlement order.
Are you, in this matter also you are not ready with the affidavit service?
There was difficulty to 7 days, she has not come, but ready affidavit service.
Mr.
But
Ghosh,
kindly-
during the course of the day, I'll give you liberty, but you have to file that supplementary. That
That is this junior.
you will not come today.
Then, my lord, I will come, but I will.
No, don't have to come back. There is any other party, only WBSCDCL.
Yes, my lord.
Yes, what is the difficulty? What is your grievance?
When ombudsman passed an order, that the same for mishap of the not showing the regular meter readings, suddenly, in amount raised after 2 years.
You approach the GRO? You approach the grievance redressal officer?
Given the petition and so
Oh, my lord,
ombudsman passed.
whether it is maintainable or not. The
Why?
ombudsman passed draft settlement order. There is the regulation. After draft settlement order, he has the liberty to file his views. And
No, no,
after,
no.
after
Mr. Ghosh, this is premature.
yes,
No. After passing so many orders, my ombudsman against the I have permitted to hear them, my lord, to move the writ application. So it is only.
Ombudsman permitted you to move the writ application.
Not,
Move it before the ombudsman. Move the writ application before the ombudsman.
No, writ petition is maintainable, but writ petition, so many orders.
What is the impugned order? Show me the impugned order.
page 42.
For last order.
Page 42. It's a draft settlement order.
Also, final order is already passed.
And Milord,
What is the final order?
Thereafter, final order already passed, and also the
where is the,
calculation
fi-
has been made.
no, final order is not annexed.
This is also calculation, the same order. When calculation passed by the order.
What is the final order?
Now, also, final order already passed, order have been collected. This final order already, same order be passed. Same order be passed.
This writ petition is not maintainable, Mr. Ghosh.
Kindly
No.
passed. No, but it is maintainable already passed, ombudsman order.
What is the
and same
what is
order.
the occupation of your client?
Well, it is a cultivation.
Very well, I'll give you liberty to challenge the this. I'll keep the writ petition pending. Challenge the final order by way of a supplementary affidavit. At the outset, learned counsel for the WBACTCL takes an objection that the writ petition is not maintainable, being premature, since the impugned order is a draft settlement order of the ombudsman, which has not yet culminated in a final order. First up, learned counsel for the petitioner submits that subsequently a final order has been passed in the light of the draft settlement order. Push up next para. In view of such submission of the petitioner, the petitioner is directed to file a supplementary affidavit with an advance copy to the learned advocate for the WBACTCL, enclosing the final order passed by the ombudsman and incorporating appropriate pleadings in that regard. Push up such supplementary affidavit shall be filed on April 30, 2024, when the matter shall be listed under the same heading.
Disconnect the line.
Yes, next matter. Disconnected, line disconnected.
Line disconnected.
Already disconnected.
Already.
Then what can be done?
You should notice my disconnect, my lord, kindly I will pay the current bidding.
Yes, when the matter is taken up. Yes, next.
Item number 10.
Also drafted for the bank.
Yes, Samana, what is the matter? What is your affidavit of service?
Affidavit service, yes.
File it. Yes, what is the matter, Mr. Manna?
Matter petitioner before your lordship, my
Please
lord.
take the microphone, Mr. Manna. I can't hear you.
Yes. Lordship petitioner before your lordship, my lord. His mother deposited some
Take
money.
a seat, I'll call.
Some money with the bank, my lord. Cooperative bank.
Yes, yes. What happened then?
And this, my lord, same was not released when accordingly petitioner moved a petition in the Honorable High Court, my lord.
Petitioner's mother deposited money.
Money.
Mother is still alive.
No.
Say
Died.
that.
My lord, kindly come to page.
So you are the nominee.
I am the nominee.
So you wanted the money, they are not releasing it.
Not released, my lord. The order was passed as per the order of the Honorable High Court, my lord. The order passed by the bank, my lord, for releasing all the.
What is that order of the High Court?
Order here, my lord. Page, lordship, kindly page. Only to direct the bank.
Page.
Page 31. Earlier order. Only directing the authority, my lord, to dispose of giving up.
To consider the representation.
Lordship.
What is the order there on?
That order, my lord, is a ordering portion, my lord, kindly come to page 34. Bank passed this order. Paragraph 3.
Yes, let me hear them. Yes, nominee has to be paid. He is the receiving hand. You cannot say that he will not pay to the others.
No.
Pay it to him. After that, the legal heirs will litigate against him. I'll direct that.
At page, my lord. At page, my lord.
I understand your anxiety that he will not pay to the others.
We have not read to this.
Then I'll direct that.
Page 5, my lord. Once.
Page 5.
Page 5, para 12.
Yes.
It is well settled principle that the nominee does not become absolute owner of the amount.
No, definitely not.
Her only because her registered as the nominee of the deceased member. All other legal heirs are entitled to get shares. the law of succession will still prevail. Hence, to protect the interest of the legal heirs of the branch manager, the branch manager, Contai branch of prevail. Hence, to protect the interest of the legal heirs of the legal heirs, the branch manager, Contai branch,
Statement of the bank.
is ordered to pay the due amount relating to deceased claim Gitarani Panda as per norms of the bank to all the legal heirs.
Oh, that was the direction of the court.
My lord, that is why the bank manager. Otherwise, bank have no
I understand.
stake
Yeah.
to withhold the amount.
I am
to
the
pay
nominee. I am the nominee.
Where is that order?
Order,
You-
Lordship.
That quoted order, where is that? That has been annexed also.
I do not know, my lord. Only just
This order was passed in which case?
From this order.
No, no, this is your order. This is the bank's order.
Lord, order dated.
Please see para 12, the one which you placed. This is not the High Court's order. Para 12 says that after communication of the said order passed by the Honorable High Court, the respondent bank passed the impugned order.
Lordship.
This is your presumption that all the legal heirs have to be paid.
Because legal heirs, according to release of the
No, the banking norms say it has to be paid to the nominee.
my lord, my lord. But
No,
when
you cannot say.
legal heirs there is objection, my lord, at page 35.
Even if there is objection, can you adjudicate that? That is the difficulty.
Kindly pass an order, we pay right now.
The present
Objection
petition,
at page 35, my lord.
page 35.
My
Right.
lord, 35.
I'll record that. I'll record that so that you are absolved, so that the bank is not, bank does not suffer. I appreciate. That's why I said I appreciate your anxiety. I mean that the other legal.
Five legal heirs raise objection and they attended.
I'll record that. The petitioner has. Acha, have those legal heirs been implemented here?
No, my lord.
Need not.
Legal words earlier not.
Nominee only can file.
Yes.
But Mr. Manna, what about this apprehension? You will keep it to yourself?
I am the
Nominee is the receiving hands only.
they all
The bank's action is very bona fide, not malafide. But what would you do? What you will keep the money to yourself, not pay the other legal heirs.
legal yes, they are converted their caste mill or they are all
Converted caste, so they are not entitled to the money. After this, I'll not interfere.
they are all
I'll not interfere.
they are
Let
living
it be an illegal order of the bank.
father living with my entire life mill with me.
Rightly, they have converted their caste. It's their right to convert their caste.
They can be
You cannot withhold the mother's money for that.
They can be
Converted their caste. You also go and convert your caste.
They are not looking after the. I am looking over this. All of
What?
it.
They're the legal heirs. There's no will.
It is my right, my lord, to I being a nominee. Thereafter, they can.
Yes.
Sole owner of the property. Petitioner stays in the petition.
No, I am the.
I'll make it clear, very clear, that you are not the sole owner. The petitioner is one of the legal heirs of his deceased mother, Srimati Gita Panda. Srimati Gita Panda. Who's up next para? An account stood in the name of the said Gita Panda within brackets since deceased with the respondent bank. Who's up on the demise of the account holder, the petitioner solely approached the bank for release of the amount lying in the account in favor of the petitioner. Who's up? The bank initially dilly-dallied on the representation, upon which a direction was given by a coordinate bench to consider the representation of the petitioner. The bank accordingly decided the representation and passed a reasoned order, which is the subject matter of challenge herein. Para. The bank, in the impugned order, has proceeded on the premise that there are as many as 6 legal heirs of the deceased Gita Panda, including the petitioner. The other legal heirs have specifically objected to the release of the amount in favor of the petitioner alone, since the petitioner does not have the intention to distribute the money among the other legal heirs. Next para. Learned counsel for the petitioner contends that, as per banking norms, it is the nominee who is the receiving hands, and as such, the bank could not adjudicate on the rights of the legal heirs. Next para. Learned counsel for the bank justifies the action of the bank on the equitable ground that the petitioner has expressed intention to defeat the rights of the other legal heirs. Next para. although the action of the bank by passing the impugned order was fully bona fide, comma, inasmuch as the bank took into account the contentions of the other legal heirs and in view of the express intention of the petitioner to keep the amount to himself, comma, refused to distribute the amount to disburse the amount solely to the petitioner, comma, the said action is not sanctioned by the law. Full stop. Banking regulations and norms require that the amount lying in the account of a deceased have to be released in favor of a nominee. Full stop. Next para. The bank was fully justified in observing that the nominee is merely the receiving hands and not the sole owner of the entire amount. Full stop. However, comma, be that as it may, comma, the bank, neither the bank nor the writ court has the option to adjudicate the civil rights of parties. Full stop. Although all the legal heirs of the deceased account holder might have right to the money, comma, it is solely the nominee which is to be the receiving hands as per the banking norms, for which the bank was duty bound to release the amount in favor of the nominee, sole nominee, that is the petitioner. Push up next para. As insofar as adjudication is concerned, comma, it is always open to the other legal heirs of the deceased account holder to approach the competent civil court to stake their claims in the said money. Full stop. It is also well settled that mere nomination does not entitle a person exclusively to the money lying in the account of the deceased account holder. Full stop. Be that as it may, comma, this court and the bank are helpless insofar as the question of adjudication of civil rights are concerned. Full stop. The said prerogative lies with the competent civil court if approached by the other legal heirs. Full stop. Accordingly, WPA 4158 of 2024 is allowed on contest, thereby directing the bank, respondent bank, to release the account lying in the amount lying in the account of the deceased account holder Gita Panda in favor of the sole nominee, that is the petitioner, comma, only after being fully satisfied that the petitioner was actually mentioned as the sole nominee and banking norms otherwise permit disbursal of the amount in favor of the sole nominee. Full stop. Such amount shall be disbursed in favor of the petitioner stroke nominee within a fortnight from date, subject, comma, however, comma, to the entitlement of the other legal heirs of the deceased account holder to claim their shares out of the said money from the petitioner. Full stop. If so approached, comma, the petitioner shall be duty bound to distribute the shares of the other heirs of the deceased account holder to them at the earliest. Full stop. In default, comma, appropriate steps may be taken by the said said other legal heirs before a competent civil court. No others to cause certain civil.
Grateful. ও দিয়ে দিতে বাধ্য।
Matter number 11.
Lord, I appear for the petition.
Petitioner, yes.
Yes. My lord, all the respondents have been served and there is also an affidavit of
I am appealing for the state respondent, my lord. Kindly take this matter tomorrow because, my lord, today I am not ready, my lord. I am not ready.
Your problem.
filed long before.
My lord,
Yes, what is the matter?
My lordship need not see this
Actually,
brief at all.
without my knowledge, my lord, the matter was
You just hear
mentioned.
me, you will understand.
No, no notice of mentioning upgradation was given.
No, my lord, no notice
That
was
is
given
part-
to me.
Huh?
Upgradation notice, where is the copy?
Upgradation and huh? No, affidavit service না যে নোটিস মেনশন করেছো সেটা হ্যাঁ it was on mail. Where is that mail?
Mail.
Yes, I thought you were going to submit something which may resolve the issue.
Well, I
Yes.
think he
Please
is not
open,
yet-
then let your learned friend hear you. Yes.
just hear- My lord, in our country, this is a very common phenomena that we have anybody and everyone in their
Take the microphone.
yes,
Yes.
anyone, my lord,
Yes.
in who is producing any food products can say anything and everything, and there is hardly very enough amount of law. Now, in a very recent times, my lord, there are two incidents. I would just say a little bit and then I'll come to my case. The medical association had to file a writ petitions before the Honorable Supreme Court because the Patanjali Ayurveda my lord, in the name of that, that this is an Ayurveda, they were making advertisements in various medias like anything and everything. Now they are facing the contempt.
Apart from reviving a dead person, everything under the sun.
Yes,
Yes.
yes. And the other very recent matter, that is last 2 weeks in Kerala, there is an independent society comprised of some very, very spineful doctors. They did a research on protein supplements, particularly from the plant-based.
I should release on personal note.
And a
If it's protein
plant-based,
supplement.
plant-based.
Even plant-based.
Is not casein or
Even plant-based. Yes.
Now they found then Indian made these supplements, the majority of them, firstly, they don't even have, sometimes not even 1/5 of what they are claiming. And secondly,
What? Protein content?
yes, and that's not a big thing. Secondly, most of the plant proteins, these companies, they are actually, on the laboratory, it has been found that toxic things are there. Now, Mala, this is only nothing to do directly on this. Now, there is, I did say that there is law are not very well equipped, but still there are some laws. The petitioner before your lordship is an NGO and it's a registered society, registered from 2014 in the West Bengal Society Registration Act. Mala, one of their objects and working is they have their YouTube channels, they do a lot of research works, and they try to make people aware on this sector. Now, Mala, there is a brand Doctor's Choice mustard oil. Mala, there is a specific regulations. If Lordship State will kindly take regulation 10(2) of the under the food safety 10(2) to down. 10(2). Mala, there is a flag.
You also please listen to him so that you can come prepared tomorrow. Yes.
Lordship may kindly see that 10(2), this is a regulation. It is a regulation under the Food Safety Act. It's a regulation 2018. There shall not appear in the label of any package containing food for sale the words recommended by the medical or nutrition or health professionals, or any words which imply, Lordship may kindly mark imply, or suggest that the food is recommended, prescribed or approved by medical practitioners or approved for medical purpose. So at least there is a law. We made a complaint at page 148 before the appropriate authority under the Food Safety Act. The only reason today, my lord, we are before your lordship is seeking, there has been inactions, let him take a decision on it and nothing more than that.
They've given a representation.
Yes,
What is
that is at page 148. I know that this must be the first round of litigations, but in this round, this is of dated, my lord, November 23, and I am told that this.
Who is to take steps on this?
My lord, this is to the number 1, the respondent number 2. Sorry, respondent number 3, food safety officer.
He has to take steps.
Yes.
I'll dispose of the writ petition by directing you to consider this
Within a,
representation.
within a stipulated time.
Definitely, yes. Do it urgently. What a grimace.
But, so far, respondent number 3 is.
My lord, I am appearing on behalf of the Food Safety Authority, my lord. I am appearing.
Food safety officer also, respondent 3.
My lord, I am appearing.
I'll direct you to consider the representation.
My lord, in this case, my lord can pass this order. My lord, we will dispose
So
of
I
this.
can pass, should I?
My lord can dispose. We are ready, my lord, to dispose of these representations. But in the meantime, my lord, we have already served a 3 improvement notice, my lord. My lord, as per section 30, if your lordship kindly come to section 32 of this Food Safety Act, my lord.
Food Safety Act, I don't have.
My
What
lord,
does it say?
My lord, if the designated officer has any reasonable ground to believe that the food business operator has any fails to comply with any regulations, my lord, they can
Section
issue
33.
32, my lord.
32, right. So you have issued improvement notices
My
to
lord,
this concern.
my lord, already issued 3 notices, my lord. And in this case, my lord, they have disclaimer provided their lordship that the Doctor Choice has their trademark. They have already, lordship, they provided this.
Okay, very well. Then I'll ask you to file a report instead of
My lord,
relegating it
my
direct to you. Since you have taken steps, apparently, Mr. Dhar, I'll direct them to file a report with a copy to them. I'll give you 1 week for that report. Whatever steps you have taken, disclose. Disclose, give a copy to them so that we can take a decision. We can take it a step further. You are for the union.
No, I have for the state of West Bengal.
Thank God,
already
yes.
Also three.
The,
Very well, whatever has
But
been.
only thing, well, kindly see this line. I think, well, it can be disposed of right now.
What is this?
ঝামেলা করেছে আমি যেগুলো নেই কিছু মামলা সেগুলো
What is this? Tell me what is this? Yes, এটা ফেরত দিয়ে দিন. You have got another copy?
Yes.
You have got another copy?
I have.
Yes, what is it?
In view last at the issuing authority additional secretary government of West Department of Health and Family Welfare. In view of the above, and I am skipping over this 3 paragraphs. 4, paragraph 4, my lord. In view of the complaint was forwarded to the undersigned to the regional director, Eastern Region, FSA Sassan by dated 20th April 2023, Annexure E, as the matters pertains to the Central Licensing Authority. It was also requested to the good office of the regional
The usual
director.
passing the buck, Mr. Sengupta. In
Yes.
every matter, you are passing the buck. This is another exercise. I'll direct them to file a report. Learned senior counsel appearing for the petitioner contents that the petitioner.
my lord, one indulgence, my lord, instead of 1 week, my lord, can you give a 2 weeks, my lord?
Very well. The petitioner is a non-governmental organization registered under the West Bengal Societies Registration Act, engaged inter alia in ensuring the safety of consumers
Yes.
of consumers in general. Full stop. Next para. The present challenge pertains to the alleged inaction on the part of the respondent authorities on a complaint lodged by the petitioner with regard to fraudulent, deceptive and unfair trade practices adopted by the private respondent. Full stop. Learned senior counsel places reliance on regulation 10 within bracket 2 of the food safety and standards within bracket advertising and claims bracket close regulations 2018, which stipulates that there shall not appear in the label of any package containing food for sale the words within double inverted recommended by the medical or nutrition or health professionals double inverted close, or any words which imply or suggest that the food is recommended, prescribed or approved by medical practitioners or approved for medical purpose. Full stop. It is alleged that such norm is being palpably flouted by the private respondent. Full stop. Next para. Learned counsel appearing for the
1, 2, 3.
Only one thing, there is no private
My
respondent
lord,
because
আচ্ছা
our prayer was only
আচ্ছা
for
যেখানে যেখানে
taking a
প্রাইভেট
decision.
রেসপন্ডেন্ট বলেছি সেখানে সেখানে করে দিন প্রাইভেট রেসপন্ডেন্টটা কেটে তার বদলে ওয়ান বাজবাজ রিফাইনারিজ লিমিটেড আন্ডার দ্য ব্র্যান্ড নেম উইদিন ডাবল ইনভার্টেড ডক্টর অ্যাপোস্ট্রোফেস চয়েস ডাবল ইনভার্টেড ক্লোজ ফুল স্টপ দিয়ে নেক্সট you are appearing for whom then?
my lord, I am appearing in lordship 3, 4, 5, 6, my lord.
Learned counsel appearing for respondent numbers 3, 4.
My lord, my lord, I'm 4, 5 and 6, my lord.
Learned
5.
counsel appearing for respondent numbers 4, 5 and 6 contents that already steps have been initiated by the said authorities by issuance of improvement notices under section 32 of the Food Safety and Standards Act 2006 against the alleged perpetrators. Full stop. Next para. Learned counsel appearing for the state respondent hand 1,
2, 3.
very well. For respondent numbers 1, 2 and 3 hands over the copy of a written instructions indicating that a complaint was forwarded by the additional secretary to the government of West Bengal, Department of Health and Family Welfare within bracket food safety bracket closed to the regional director, Eastern Region, FSSAI on April 20, 2023, but no action taken report has been available as yet. Full stop. Next para. In view of the stand taken by the respondent numbers 4 to 6, as regards steps having already been initiated with regard to the concern of the petitioner, the said respondents are directed to file a report in the form of an affidavit upon circulation of advance copies of the same two learned counsel appearing for the petitioner as well as the other respondents on the next returnable date, full stop, the matter shall be placed for hearing under the same heading on May 7, 2024 for passing further orders and for filing such report by the respondent numbers 4 to 6.
That should be kept in records also.
The instructions filed today be kept on record. Let us come back, please. এই বইটা ফেরত দিয়ে দেবেন একটু ওনাকে। Yes, প্রথম লাইনে affidavit service.
Item number 12.
My petition. Item number 12, my lord, I am seeking only 2 days time, my lord. If lordship give it, while
Upgraded matters, no.
No, I am not on that, my lord.
Elections are going on.
No, I have not yet received any instruction, my lord.
So what?
It was served to them long back, my lord. No, my lord.
Your client's fault.
Kindly, my lord. This
No,
is
no,
a matter, my lord. Only 2 days, my lord.
And that is the reason why, my lord, I have been mentioning this matter upon notice, my lord.
What is the matter about?
My lord, this pertains, my lord, to the tender which was floated by the government, the state government, for hemoglobometers, my lord. Under the Anima Mukt Abhiyan of the Indian government, my lord, they were to float tenders, and the tender is to have certain specifications. Only those people who have those technical specifications with regards to, you know, the medical device, which is used something like a glucometer, the hemoglobinometer, and this was to be used by the ANMs, the Anganwadis, healthcare centers, and
So the participants have to have those qualifications.
no, the participants have to have the technical qualification in the sense that their device has to be a device which is under class A and class B, and that they have to have certain certifications from the body which has been authorized to give those certifications. So but that was, may I have my lord's leave to file the affidavit of service.
So what is the grievance now?
But the grievance is that, first of all, the technical specification with
So Mojumdar, you are for the private respondent.
But I don't know not whom my learned friend has implicated. Not I appear for the respondent number 4, who is not a participant bidder. I'm a manufacturer, but not the participant bidder is not the distributor who has been probably selected.
Yes.
Very well. Please continue. Yes. Very well, Mr. Mojumdar. Yes.
Addressing my learned friend's first query, the technical, I'll take my lord for the technical.
So what is the present grievance first? Then we'll.
Present grievance, my lord, is that the respondent number 4, my lord, who has been another qualified bidder along with me with regards to the technical specification and crossing the product demonstration. That he has been, both of us were there for product demonstration. At the time of product demonstration, there was the technical committee had come forward with a finding that the device of my learned friend is a device which was used for clinical purpose, and for the same they wanted a legal opinion. But we have been time and again asking the department that, first of all, for the purpose of transparency, what is the outcome of such legal opinion which you have sought? One. Secondly, we have also brought forward to the technical committee that as per the tender specifications, the technical qualification which was required was that accreditation by the notified body. And the certificate of the respondent number 4 is not a certificate from the notified body for class B or for medical device quality management services.
Yes.
This is my second system. Sorry. This is my second.
What has been done? It has been given to them.
Till date, the financial bid was open without my knowledge. Thereafter, I've been writing on numerous occasions with them. None of my communications have been replied to. But as on this date, I understand the LOI has not been issued. So today, the difficulty is that without dealing with all these pertinent questions which I've been raising in my communications, they will any day go ahead. I'm not.
But you did have an opportunity. There must have been some opportunity where you have to where you can clarify your
Yes,
doubts.
Lord. I have numerous communications made to them, but they
This does not vitiate the tender process.
Yes, Lord.
Why?
Why the tender process? Lord?
Show me the relevant clause.
Yes, Lord. Yes, Lord. Lord will kindly take with me.
They have a right to seek their own legal opinion.
Yes,
It's the tender inviting authorities who have the discretion.
Petitioner is not a participant.
I will deal with
This
it.
is not a participant.
I knew this was coming, that I will demonstrate that also. I knew this was coming. That's why I said addressing
The
Mr.
Poshumoli knows only that you are not a participant.
Paragraph 6, my lord, her own admission.
So then what is your locus standi?
I will demonstrate.
What is the locus standi?
Lord will kindly have a look at the tender document.
You are not a participant in the tender process.
Through the tender document very categorically mentions who all can come and bid. Lord will kindly have a look at the tender document first. But it starts from page 25. Notice inviting tender. Now, Milord will kindly see who all can participate in the tender, which is at page 28. I'm sorry, Milord, not 28. I'm sorry, Milord. Yes, Milord, page 28. Sorry, Milord.
28,
Who can
yes.
bid? Clause 7, who can bid? Manufacturing company who is manufacturing the device can bid. The selected manufacturer bidder may hire authorized distributor who will deliver the goods at the consignees and collect payment from NHM on behalf of the selected bidder. However, award of contract will be issued and agreement will be signed with the manufacturer bidder. Or, Milord, the manufacturer's subsidiary in India can bid. Or, Milord, manufacturer's authorized distributor or business partner.
You have
I
participated through your distributor.
through my distributor, Milord. And so has my learned friends, client has participated through the distributor.
Now show me on the
Milord,
merits. Where
yes,
is it?
Milord. Now I will show, Milord, the requirements that I was categorically on. Milord will kindly take page 30. This is what I will rather I would come to page 30 later. Let me show other terms of the contract first.
38.
Page 32 first. This, Milord, is the contents of bidding document. I will rely upon 18.4.
Yes.
The specifications are the minimum requirements for the products. Products offered must meet or exceed requirements mentioned in technical specifications. The products shall conform in strength, quality, and workmanship to the accepted standards of the relevant industry. Modifications or additions to basic standard products or less size or capacity to meet these requirements will not be acceptable. Now, Milord will kindly take the qualification which has been mentioned at page 37. Milord will kindly take page 36 first. Bid B. So, Milord, bid B requires that I have to put in comparative data table for technical specifications, and the certification will be Milord 4, bid B serial 4. 2 sets of brochures of the product of the offered product or model. Then 5, European CE Declaration of Conformity on Compliance with In Vitro Diagnostic Device Directive 98/97 EC. US FDA. This product must be enlisted under US FDA. This is for the US market, or BIS certified. This thereafter will come to page 37, categorically mentioning what should be the required qualification. They will kindly take evaluation of bids and then come to III, evaluation of specs indicator. Bidders will have to arrange for a functional demonstration of the offered equipment on the notified date. The evaluation of the spec indicator will be made based on the reports of the functional demonstration of the equipment. The functional demonstration that is on-site or off-site of the equipment is purely at the discretion of the Technical Bid Evaluation Committee, and its input shall be treated as only corroborative in nature and will not be a substitute for technical evaluation of the document submitted along with the bid. The decision of the Technical Committee in this regard will be final. Functional demonstration of the offered model will be held at Kolkata. Bidder has to comply with all essential parameters of the technical specifications except deviations which will be considered minor and acceptable by the team of experts to be engaged by NHM to take working functional demonstration of the offered equipment. A bidder will be considered technically qualified if I, 1, comply with I and II and qualify in III above. Then Milord will kindly take with me page 53. Which mentions the technical specifications. The first technical specifications are the general.
Even if you comply with the technical specifications, you have to overcome 3.
Yes.
If in their evaluation, the evaluation right is there.
I will come to that.
If you have lost there, then nothing to do.
Lost them. I will show that. I'll demonstrate that. We will then take the certificates 4. First of all, 3 demonstration. They should have a demonstration session during the tender process, wherein a nominal value, high value, and low value ID will be demonstrated. Certificates, instrument which has been tested and validated in fields in India. Product certification.
You must have qualified in these. That's why you are given that
have.
demonstration.
The reason why I'm showing this is that quality certification. Let me kindly see, it needed a certain specification, the ISO certification.
Yes.
So this is required for all MDQ certifications. Now, let's question upon me was onto me. I will first take the take Millards through the various certifications which I have and the
This
respondent
evaluation,
number
you were not selected. After this evaluation, you were not selected.
No, Millard. I have not been made aware of as to what
Why
is the
should you
outcome.
be made aware of
Millard,
anything?
Millard, I will. Millard, I have, Millard, because I have been writing to them on the day
They
of
have
the technical
evaluated. They
demonstration.
have evaluated and found you unfit.
Millard,
So that's their decision.
Millard, it's not Millard, will kindly come to page 96. This technical specification on the day of technical demonstration. Both I and the respondent number 4 had participated.
Yes.
Now, that with regards to the respondent number 4, this was what the communication was made at 96A.
No, I did not participate.
He had participated through
No, I did
our
not participate.
biogenics.
Page 28 is not the purport of no manufacturing unit participating through its distributor. Please have a look at page 28. Who can bid? Clause 7. Manufacturing company, 1. 2. Manufacturer's subsidiary in India. 3. Manufacturer's authorized distributor or business partner. Not 3 are distinct legal entities. One manufacturer may have several distributors, out of which 1 or 2 may choose to participate.
Now, to put at rest Mr. Majumdar's contention, we will take page 96 once. Either he says that he has not participated. Either he says he has not participated. Therefore, his name would not feature anywhere in any of the documents. We will kindly take page 96A.
Correct.
96A is a photocopy of the document which was signed by the committee on the day of the demonstration, of which I made a type copy at page 96. We'll see name of the bidder, Om Biogenics Private Limited. The company which is the manufacturing company is called Sensacor Private Limited, and their product is Hemospark, which is Mr. Majumdar. That's why I was saying that I have participated in the tender.
Has participated.
Yes, Lord. Distributor has participated. Distributor is he's my
entity.
agent. Distributor is my agent. That is why I had shown the document whereby who can bid. Person manufacturer can himself bid or can bid through his distributor or a business partner.
Can't bid through. Please see the distinct entities in A, B, and C of 7.
So then I see there was no reason for the mention of Sensacor there.
Manufacturing company's name should appear.
Mr. Mujum, let us proceed. Yes.
Yes, Millard.
Please continue. Page 96 I have seen.
Yes, Millard. We'll see
So to be
the
used in clinical lab only, therefore they sought legal opinion.
Yes, Millard. Now I will take you, Millard, to the
Be a bit
concern.
fast because this is a motion bench. We have to be fast.
Concern of the entire purpose of having this globometer was.
Where is your communication after
required.
this?
But my communications are numerous after this. We'll start take from page 98 on.
Were you rejected?
No communication to me whether I've been rejected or whatever has happened.
Name of the bidders is Bashanti Pharma and Om Biogenics.
Pharma is my
Technically
Bashanti
qualified
Pharma
based
is
out
my
on price bid.
You are Rig Nanosystems, which is not a
Yes,
bidder at all.
Look, I have participated through Bashanti Pharma. Bashanti
You
Pharma
cannot
is
participate through anybody.
Yes, no. Who can bid?
No.
Yes, Millard.
No.
Millard will kindly
Please come to page 28 once.
Yes, Millard. Kindly see page 28. Who can bid?
Yes. Independently, these entities can bid.
Yes, so Millard,
You are a manufacturing company.
Yes, Millard.
You have not. You have not put in your bid as a manufacturing company. A does not apply.
Yes, Millard.
Manufacturer
applies to me.
subsidiary does not apply. C says manufacturers authorized distributor or business partner.
So,
Then it had to be manufacturing company through its authorized distribution, which is not the language here.
Millard. Yes, Millard.
What is?
Manufacturer's authorized distributor will be the distributor.
Your distributor had to come before this court then.
Millard, in all communications and the certification which is required to be sent to for participation in the tender is the certification of the manufacturing company and not the distributor's certificate, Millard.
No.
Millard,
Then there would not be two
understand that.
categories. Then it would be only one category. Manufacturing
the
company
reason why-
either by itself or through its
The
distributor.
reason why this was mentioned is that for the purposes of making it convenient for distribution of the device at the rural areas in Bengal. Then we'll kindly see this. What was the entire idea? Then we'll see. In
You are not
transit-
even a bidder.
Millard,
You are no entity at all.
I'm a
You
bidder.
are a non-entity insofar as the tender is
I,
concerned.
Millard, I am the manufacturer, and the participation has
Why
been
didn't your
made by the
distributor come in? Why has the distributor not challenged? What happened with the distributor? Fallout with the distributor?
no fallout. We are still together. And we're always.
And on merits also, I don't find anything.
I will with the case. I
You
will
are found to be, your distributor was OHM Biogenics.
Yes. No, my Bashanti Pharma.
Basanti Pharma.
Mine
So
was
Basanti Pharma was technically qualified.
No, it was technical. I will
Page 97.
We'll see. We'll see.
What are you saying? You have been technically qualified, then rejected at the financial stage.
The financial bid will be opened on 6th March.
What is your cause of action? You have not yet come to your cause of action.
So the cause of action is that they are not qualified because the certificate made by them is not the certificate which is by the notified
Cannot look into
body
that.
under the rules, Millard. We will kindly.
We cannot look into that.
Millard will have
You have participated, you submitted to the jurisdiction, you were technically qualified, you participated at all stages.
Yes, Millard.
When was the financial bid opened?
On 6th March.
When did you file the writ petition?
I have filed this.
After that?
Yes, Millard, after that.
No, sorry.
Will kindly bear with me for one moment, Millard. The reason why I've challenged.
I've borne your submissions for many moments.
One more thing, then we'll have a look at the certification once.
Tender matters, we are very cautious and
Yes, very cautious.
here no.
If there is, if the entire process, is on the basis of the first, if the specification which was required for them to participate, if they are not.
No, ma'am, it is the discretion of the tender inviting authority.
If that is lost,
there is nothing
else. We will kindly see the medical device rules once.
Why should I look into that? It's their discretion. They have chosen it to be technically qualified.
If
You did not make any demand at any point of time.
Point in time.
Where?
See,
Regarding their technical qualification.
Every communication, starting from but in fact, the first.
Show me one of the communications.
Yes, Lord. We will kindly take one communication as early as.
Page. Give me the
yes,
page.
Lord. The page will be. That 98 is my legal notice to them, and before that, we will kindly come to page 90. I've always been writing to them. This is not before the financial bid. 27th March 2024.
After the technical stage was over.
Sorry, Millard?
After the technical stage was over.
No, Millard. Before the technical stage. We will kindly see page 90 pertaining to the above Sensaco quality certificates of ISO 13485 is also not valid because as per the rule 11 under chapter 3 of MDR 2017, NABCB under the Quality Council of India registered under Societies Act, BSI is no longer listed under NABCB as a notified body. Then, Millard, for the purpose of MDQMS, Millard, it is not a body which can give them a certification. On the basis of that certification, Millard, they are looking to get to participate in the tender, and that is what I have been raising since day one. Millard. All these communications of mine, Millard, will see 27th March, there are 27th February, Millard, then it's on 5th March, 6th March, 11th March, 14th March, 15th March, 20th March, even Millard, even in January 2024, that at page 91, Millard, will see. We'll see, this is Millard, at page 92. Declaration of Quality Certification of Equipment ISO 13485. None of my communications have been answered. Now, for a moment, look at the certificate. Manufacturing license as well as certificate. For we'll see at page.
Cannot go into so much.
Just one more. Has been
inviting authorities discussion.
All these
There's a limit to how far we can look into a tender inviting authorities discussion.
I would not have pressed for an order.
We cannot assess. They cannot assess the as evidence the raw documents to be.
It is very apparent that these
not so apparent. No.
We'll kindly have a look at
whether the declaration of quality certification was.
Kindly have a look at my certificate, page 74,
no.
Then their certificate,
no.
as well as the license. The manufacturing license we'll see. We'll see. The 74 is my certification.
Yes.
This is for medical device quality management requirement.
Yes.
And this has been certified to me by the body, which is at page 93. At page 93, serial number 11 is the body which has certified me, given a certification to me. And what my manufacturing license is at page 79. Which says
your manufacturing license is not in dispute. Their manufacturing license.
I'm just.
What is that?
Yes, Lord. That is also there at page. But first, I will show you their license, their certification at page 89.
If the tender inviting authorities felt that this is sufficient, that their discretion is final. They are choosing their
we have written
bidders.
to CDSCO, the authorized body, and there is this body. We'll see the quality management systems at page 93. This body is nowhere mentioned.
No interference, Ms. Shah. We cannot look so much into.
The difficulties with this is not this is for the purposes of medical benefits.
And you waited for the financial bid to pay for the challenge.
So 6th March was the financial bid which was opened.
When did you file it?
But I had filed it thereafter in March, 27th March.
No, sorry.
But I have been writing every time, even my legal notice has been left unreplied, Willard. The legal notice at page 99, which is 5th March 2024. Before the financial bid, Willard. We'll see at page 99, the paragraph 2A, I've mentioned everything in details.
Yes, Madhav
that I have said.
No, Ms. Shah, sorry. The petitioner, challenges
Not the entire purpose of
a tender process,
the clinical
particularly particularly on the ground that the private respondent number 4, who was selected as the successful bidder, did not comply with the qualifications required to be met as per the tender. First up, it is contended that the tender was for medical instrumentation of some sophistication, and as such, non-meeting of the standard by the respondent number 4 was detrimental to the public interest. First up, next para, learned counsel submits that the petitioner had made several representations to the tender inviting authorities regarding the lack of appropriate technical qualification of the private respondent number 4, which were not replied to by the tender inviting authorities. First up, it is also pointed out that after a performance test of the petitioner's authorized distributor and the respondent number 4, it was found that the instrument of the petitioner was within double inverted close, but legal opinion was sought, on which no light was shed subsequently by the authorities despite repeated queries by the petitioner. First up, next para, learned counsel appearing for respondent number 4 takes an objection to the maintainability of the writ petition on several grounds. First, it is contended that the tender document itself contemplates 3 categories of entities who can bid. The first category is a manufacturing company, the second is manufacturer ' subsidiary in India, and the third manufacturer ' authorized distributor / business partner. It is contended that all the 3 entities are distinct and separate entities, for which they were mentioned separately in clause 7 of the bid document. The petitioner, as a manufacturer, cannot claim to have locus standi to file the writ petition, since the petitioner itself did not participate in the bidding process at all. It is argued that even if the authorized distributor of the petitioner participated as a bidder, the said entity acted in its independent capacity under clause C of subclause C of clause 7 of the tender document, and as such the petitioner cannot have any locus standi to prefer the writ petition. Next para, it is further submitted that respondent number 4 itself also did not participate in the tender process. It is argued that it might very well have been that the distributor of the authorized distributor of the respondent number 3 had participated in the tender, but that does not make the respondent number 4 party necessary or proper party to the present writ petition. Even on merits, learned counsel for the respondents controvert the allegations made. Next para, certain features of the present matter are clear from the averments in the writ petition as well as the arguments. Next para, first, the financial bid was opened on March 6, 2024, whereas the present writ petition has been filed thereafter, challenging the competence of the private respondent number 4 ' distributor at the technical stage. The ground taken, one of the grounds taken in the writ petition is that the distributor of the private respondent number 4 did not qualify on technical count. Push up, however, comma, since the petitioner took a chance by waiting for the financial bid to be opened and having lost therein, comma, has preferred the present writ petition, comma, the writ petition ought not to be entertained on such score alone. Push up, next para. Secondly, comma, it is well settled that the discretion and primacy of opinion lies entirely with the tender inviting authorities as to whether the bidders have satisfied the technical criteria as stipulated in the tender document. Full stop. I do not find any palpable violation of such norm and or any patent malafidez on the part of the respondent authorities or bias in choosing both the petitioner's distributor as well as the respondent number 4 as technically qualified. Pushed up, next para. Insofar as the argument as to the legal opinion being sought by the tender inviting authorities upon the technical demonstration of the petitioner, comma, the said development is a total non-issue insofar as the present matter is concerned, comma, since despite such reference to legal opinion, comma, the petitioner was subsequently chosen to have been technically qualified at the initial stage, which is evident from the technical bid evaluation summary dated March 5, 2024, annexed at page 97 of the writ petition. Thus, comma, the petitioner's distributor, authorized distributor having qualified, comma, the petitioner cannot have any grievance on such count.
Just now that I've been mentioned, I've been told that 6th March the bid was not open. Then we'll see page 113.
What is that date?
The financial bid was open only on 26th March, and 27th March I came to the court and I filed my writ petition.
26 March. Next para. Insofar as the objection taken by the respondent number 4 is concerned, comma, there is also much substance in the same. Next para. On a literal interpretation of clause 7 of the tender document, comma, 3 categories of participants were contemplated therein, hyphen, manufacturing company, comma, manufacturer apostrophe subsidiary in India, and manufacturer apostrophe authorized distributor stroke business partner. Full stop. If the interpretation of the petitioner that a manufacturing company can also participate through its authorized distributor, comma, the latter acting as an agent, comma, is to be accepted, comma, the said interpretation defeats the very purpose of 3 categories having been distinctly and differently mentioned in clause 7. Full stop. The very fact that manufacturer's authorized distributor stroke business partner has been mentioned as a different and separate category from a manufacturing company clearly indicates that a manufacturing company has to participate in the bid in its own capacity and not through its authorized distributor, comma, the latter being also an independent entity in its own right insofar as the submission of the bids are concerned. Full stop. Hence, comma, the petitioner also does not have locus standi, comma, being an independent juristic entity different from its authorized distributor which participated in the bidding process, comma, from preferring the present writ petition. Full stop. Also, comma, the same logic applies to respondent number 4, comma, which did not itself participate in the tender process, which is evident from the documents annexed at the writ petition, annexed to the writ petition as well. Full stop. It might very well be that the respondent number 4 apostrophe distributor had participated, but the same does not make any difference, comma, since the said entity, comma, under the contemplation of clause 7 of the tender document, comma, is entirely distinct and different from the respondent number 4. Full stop. Hence, comma, the writ petition fails on all counts. Full stop. Thus, comma, WPA 9106 of 2024 is dismissed on contest without any orders to cost. Affidavit of service filed to be kept.
All along, my communications have not been answered.
Yes,
Even on 23rd March, but also I am told that no LOI has been issued till date. that also till November 24.
No,
I
Miss Shah,
don't understand
that is
the
sufficient.
haste, because till November 24, my devices are well in warranty, my lord.
Next.
Item number 13.
Yes.
Obliged, my lord, deeply obliged.
Thank you. Who is for the petitioner? You are not for the. Yes. What is the matter, Mr. Chakraborty? Service. Affidavit.
Service.
State.
There is one private respondent in this matter.
Private respondent has been served, Mr. Chakraborty.
Private respondent has been served, but after
What is the matter
mentioning
about?
the petitioners are the commissioning couples under the assisted reproductive technology. They
You are a
had-
commissioning couple.
Yes.
Right.
They had a son. There is a premature death due to an accident. The couple decided to take a second child.
You want a relaxation of the age bar?
Present case is, my lord, the wife is within the age bar. The
Is it,
husband
I passed an order on this similar.
husband crossed the age bar.
One of them crossed.
Because of that, it is the decision between the couple that
They cannot take your gamete. They
yes,
cannot take the husband's gamete.
donated gamete. And thereafter, by medical examination, it was the opinion of the doctor that the wife will have to take the donated ovum also.
Yes.
Position is that donated sperm and donated ovum.
Huh.
This is the position. And both the
What do you want now? So that has been allowed then?
but not allowed, my lord. The clinic said that under such situation, unless an order is passed by the appropriate.
Have you got a copy of the act? Assisted reproductive.
What I've got. My lord, 21G.
What is your name? বসে আছো কেন?
Act also.
আমাদের ছিল তো একটা মামলা এসেছিল। Did I look into?
21G.
My lord, first I would request my lord to see 2A. 2A, the definition, my lord. Assisted, what is assisted reproductive? Then 21G.
So we have to look into 2E also. 2E as well as woman, 2U. These are separate entities. Commissioning couple and woman are separate entities. And which is the provision which restricts the age?
21G.
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 What does the clinic say now? I mean, what is the cause of action of the writ petition?
Clinic actually says that unless there is a
Age
valid
relaxation, my
permission,
lord. If the clinic says there has to be an age relaxation,
then we can do it. This is the
এটা অন্য
stand of
act.
the clinic.
অরিত্র এটা অন্য act. The
Presentation-
clinic says that?
If I get a valid permission from any authority, I can do.
What is that communication by the clinic?
Actually, they communicated in a different manner. Kindly come to
page 15, my lord, subject to correction,
Page
page 15.
15. Yes.
last line. Please grant their special permission on individual basis. Some medical observation is there and it is there. And my prayer made before the appropriate authority is not decided.
You are suffering from poor ovarian reserve along with it. So can you carry the baby?
Lord, it is kindly come to the second paragraph. He is suffering from the fibroid in uterus and for which they need.
So you want your ovum to be used?
No, it is their specific opinion. I have stated in the writ application that both donated sperm and donated ovum.
That possible.
Both donated.
Both donated.
Then
in
why
that
don't you
case-
go for adoption then? One child will find a home.
In that case, there will
I mean,
be no-
I am not in a position to advise you, but is that permitted here?
No, madam, subject to it, that is possibly another act that doesn't prescribe. And my lord,
Let me hear, Mr.
But I'm not,
Mr. Tanachak.
just kindly see, this is why this age limit, the central government has
No,
given.
no,
us.
keep it with you for the time.
But-
Let me see the act first. I always go by the bare act first, Mr. Chakraborty.
No, that much I,
Which is the, I mean, what should I look into? 21, let us see.
21.
Yes,
can-
21 age 21G deals with the clinic shall apply the assisted reproductive technology services to a woman above the age of 21 years and below the age
No,
of
Mr. Pinaki Chakraborty, now the other Mr. Chakraborty is right. Please come to definition section 2A, which he was relying on in the first place.
Yes.
So it has to be with all its grammatic variations, all techniques that attempt to obtain a pregnancy by handling the sperm or the oocyte outside the human body. In the first place, it has to belong to you. It will be handled outside the human body and transferring the gamete or the embryo into the reproductive system of a woman. So it has to be the woman, either you or the woman out among the commissioning couple. If it's a different woman, then surrogacy comes in. It's a different law.
Subject to your lordship's correction, what I submit.
Yes.
2H is also important.
2H, let us see that.
Gamete donor means a person who provides sperm or oocyte with the objective of enabling an infertile couple woman to have a child. Their donation of
If
sperm.
both of you donate, I mean, where is the scope of you? Here, both of you are willing to donate. I mean, seek donations.
Yes.
See, both of you go forward with donated gametes or sperms. Then where is the question of assisted
What
reproductive?
I have understood, my lord, under 2H, it is permissible because
Gamete is permissible. Acha, very well. Because woman also herself can go for that. You says woman. Woman means any woman above the age of 21.
Yes.
All right, yes. Mr. Chakravarti, what is your object? I mean, what do you say on this? Why is it not
instruction-
permissible according to you?
Age limit. Age limit was the criteria. And
No,
my-
apart from age limit, there is no bar in them obtaining gametes from others.
according to me, what if the both are outsides? If I can consider.
Yes,
this
where is
act-
the
this-
bar?
This act possibly does not come into play. If both are outside, but kindly see the purport of this. It's a vis-a-vis the clinics. If my lord sees, it is the vis-a-vis the clinics, how they will maintain and what are the eligibility criteria. But two outsiders possibly, my lord, this act, because
No, they are a couple.
they are a couple.
They are a
but
married couple.
They are a married.
Commissioning couple is a married couple.
Yes, yes, my lord, there is no dispute. My lord,
No, but please come to section 21 once. Section 21 says general duties of assisting clinics and banks shall perform the following duties. A is the clinics and banks shall ensure that commissioning couple, here that applies, of gametes are eligible to avail the assisted reproductive technology procedures subject to such criteria as may be prescribed. B says the clinic shall obtain donor gametes from the banks and such banks shall ensure that the donor has been medically tested. Then the clinic shall provide professional counseling to commissioning couple and women about all the implications, etc. Inform, help the 3 says C3, help the commissioning couple or such and such to arrive at an informed decision. Then D says shall make them aware and E shall ensure that information. Now every clinic, F says every clinic and every bank shall maintain a grievance cell. This is on the advice and all.
There has to be one has to be participate. If I can put it in this way, there has to be one has to.
Then how does the commissioning couple come in within the act?
Commissioning couple must subject to correction. If my lord sees the commissioning couple is defined.
Yes.
Means married couples, my lord. It doesn't.
They are a married couple.
Yes, but
Although that's a violation of Article 14. Actually. I mean, anyway, let us not go on. Let us forget that. We are not deciding that.
The person, my lord, here both are outside. They are trying to.
An infertile married couple who approach an assisted for obtaining services authorized. Now, let us see whether services have been defined. Unfortunately, no.
But my lord, 2A means subject to correction. But there has to be or is there subject to correction. And
yes.
Or the my lord, outside the subject to mention and
all techniques to obtain pregnancy by handling sperm or oocyte outside the human body.
But there has to. But I leave it to you. I do not. But this time.
No, I'm not sure on this. I'll have to.
That's. But I have to. Then kindly give me a 1 day's time. I want to study this act. But whether this can be two. If what I've understood that these couples cannot have it. They have to seek assistance from outside.
No, they are willing to seek assistance from.
That's why whether that act permits or not, that I have to consider. That's why I'm saying, man.
Comments on this end?
And my lord would kindly, because matters are coming, the Union of India has given why the age limit. There was a, I've been told the state
What is
government.
your age? You have crossed the age limit, both of you.
Wife within.
Wife within.
Wife within. Husband.
একটা order রেখে দেবো। The petitioners are a commissioning. The petitioners claim to be a commissioning couple within the purview of the. দাও ফাইলটা দাও নিও না। Within the contemplation of the assisted reproductive technology within bracket regulation bracket close act 2021 full stop, it is submitted by learned counsel for the petitioners that the which petitioner is the lady?
Petitioner number 2 is the lady.
That the petitioner number 2, comma, the female spouse out of the commissioning couple, comma, is still within the age limit as prescribed under section 21 of the said act, whereas the petitioner number 1, comma, the male, comma, has crossed such limit. Full stop. It is argued that even if one of the spouses fall within the age restrictions, comma, the benefits of assisted reproductive technology can be availed of. Full stop. Next para. It is further contended that both the petitioners, comma, being unable to bear a child, comma, seek to have gametes stroke oocytes OOCYTES from donors to go ahead and have a child by virtue of assisted reproductive technology. Full stop. Next para. Learned counsel appearing for the respondent authorities hands over a communication by the Deputy Secretary to the Government of India to the Principal Secretary within bracket health stroke secretary bracket health of all states containing instructions regarding reasons for prescribing age limits, and submits that in the event the age limit is crossed, comma, couples cannot be permitted to go for assisted reproductive technology. Full stop. Next para. Thus, comma, two questions arise for consideration in the present matter. Full stop. First, comma, whether, comma, if one of the spouses out of the commissioning couple has crossed the age limit but the other has not, comma, the couple can go ahead and have an assisted reproductive technology service. Secondly, comma, whether if both the couples seek the seek gamete stroke oocytes from outside donors, comma, they are permitted under the 2021 Act to go for such services. Full stop. Next para. Upon hearing learned counsel, comma, arguments are concluded and judgment is reserved in the matter. The document handed over in court today be kept on record. I'll consider this. Surrogacy Act is সঙ্গে দিয়ে পাঠিয়ে দেব। Mr. Chakraborty, that I'll also look into the Surrogacy Act to find out whether you go into the domain of surrogacy or adoption.
Thank you, Lordship.
It will have to be seen comparatively. If I find that in spite of that you can go, my bias will be in your favor. I'll try to put you in this statute.
But I'm not this type.
I understand this is not an adversarial litigation.
Absolutely not, man. This
Please call.
Item number 14.
I'm for the petitioner, my
Yes.
For the respondent number 4. My affidavit of service.
What is the matter?
Electricity matter, my lord.
You are the tenant.
I am a tenant. This case has a checkered history, my lord. May I be permitted to place the
No, need not place the entire history. What is their objection now? You who obtain an injunction, them or you?
I have obtained an injunction. They are tried to evict me without due course of law. I have filed one title suit for declaration and permanent injunction that I am a tenant in respect of the suit property under the respondent number 4 herein. And I have obtained an injunction from the trial court. They have preferred an misappeal. Misappellate court set aside the said injunction order, and we have preferred one civil revision before this honorable court. This appellate court order has been set aside.
So now there is an injunction that they will not disturb your position.
My position. Again, subsequently, they have filed one police inaction case before this honorable court that stating that this property is in dilapidated condition. They need police assistance to demolish the suit property. This was also been rejected from this before this honorable court. In this situation, I am enjoying an electricity from and meter in their name, in the name of respondent number 4. In the meantime, they have surrendered their electricity meter. I have applied before the electricity authority that kindly restore the meter, but electricity authority informed me through a letter that is annexed in page number 56, my lord, that if one consumer is willing to surrender his electricity meter, they can do so. If you need new electricity, you can apply for new electricity connection. Page number 57, I have applied. They have raised a quotation of 3,153. I have paid the same. That is at page number 66.
Due to their obstruction, Mr. Bandyopadhyay? Now?
Obstruction, the electricity
What is your stand?
This is the last letter, my lord. We have sent it to the petitioner. My lord, these are the 4.
Give a copy to him also.
Over phone, they have
right now.
NOC will leave, no, not necessary. Proper land documents. What land documents? They're admittedly tenants. Valid trade license, not. This is a commercial connection they want.
Commercial connection, my lord.
Commercial connection, no trade license, no
I have
tenancy agreement.
I have annexed in the
Trade license is required for that.
My lord,
Can't I take a connection and then start my trade?
my lord, since a commercial connection, my lord, not compulsory, but
I have annexed this in my writ petition, my lord. My tenancy.
Your trade license, there is a trade
license is
up to my lord 2011, 10-11. They have annexed it.
There is no up-to-date trade license.
My lord, there is
My
no
lord.
building at all. My lord, page 62, my lord.
No.
Trade license, they have annexed it. But my lord, I find it from, my lord, this is for the year 2010-2011.
Yes, what do you say, Mr. Bhattacharya?
Milord, what happened, Milord? Admittedly, Milord, they were tenants. Now, Milord, what happened? The portion of the building, Milord, which they were, Milord, occupying and they're carrying on that is completely, Milord, that has come down. This is a 200-year-old building. That's why, Milord, kindly see, Milord, page 62 once. This is up to 2010-11. Now, Milord, kindly see page 63, Milord. Page 63, Milord, this is someone else. I do not know what was the justification to Milord.
This is proprietor of this tenant.
Yes, the address is not telling. Address is somewhere else. And now, Milord, kindly
Proprietor's
comes
address.
to Milord, page 64, Milord. Yes.
He has obtained an injunction order.
No, kindly see, Milord, the Ghorer Bada Roshid, September and October 2022. Milord, injunction order, Milord, was ex parte ad interim order of injunction. We were not there. The court did not have the actual picture, only showing documents, Milord.
Subsequently, you prefer the misappeal where it has been affirmed.
Definitely. Milord, as of today, Milord, if your lordship wants.
Injunction means prima facie they are in occupation, that has been substantiated.
Kindly see, Milord, if your lordship wants to see, Milord.
No, I don't want to see anything.
This is the, Milord, condition. There is no building at all. The entire thing has been crumbled down.
No, but you do not say that there is no building. You say that only these are required. You have already held an inspection and raised an offer letter. No, Mr. Bhattacharya.
But the entire thing has crumbled down, Milord. This is the, Milord, of better.
There was a
Milord,
connection.
nothing. connection.
Corporation, the municipality refused to demolish.
200-year-old building by
Municipality refused to demolish because there is a tenant on the first floor.
it was not demolished by the municipality, not by us. It's a 200-year building, not Milord, not
Justice
under-
Sengupta's order takes care of that.
Milord, since Milord, it's a very Milord bad condition, it has come down on its own.
Very good.
There is no building.
The petitioner contends that the petitioner is a tenant in respect of the property in dispute, where the regarding which the petitioner filed a suit and obtained an ad interim injunction. Full stop. Subsequently, in miscellaneous appeal against the same comma, the order was stayed, comma, prompting the petitioner to challenge such stay order before this court in a revisional application, which was ultimately allowed, comma, setting aside the stay order. Full stop. Subsequently, the injunction order restraining the private respondent stroke defendant in the suit from disturbing the possession of the petitioner in respect of the property has been upheld in miscellaneous appeal. Full stop. Next para. It is also argued that in the meantime, the petitioner sought a demolition of the property and moved the appropriate bench of this court for getting an order of police help in that regard.
Private respondent.
Sorry, private respondent. Private respondent sought to demolish the which was moved a writ petition for police in on the ground of police inaction on such count. Push up the said writ petition was also turned down. Push up. Subsequently, when the petitioner sought new electricity connection in view of the private respondent having surrendered his previous connection, comma, the distribution licensee, that is the WBACDCL, was willing to give such connection and raised an offer letter, but have not yet given such connection. Push up. Learned counsel appearing for the WBACDCL hands over a written instruction where it is
not
a communication apparently made to the petitioner, wherein it has been insisted that the petitioner must produce way leave permission as per format A, comma, proper NOC of landowner, comma, proper land documents and valid trade license to get such connection. Full stop. Next para. Learned counsel for the private respondent contends that although initially an order of ad interim injunction was obtained by the petitioner, comma, the fact of the situation is that the building being more than 200 years old, comma, has crumbled down of its own and there is no structure worth being called a building on the premises as of now. Full stop. Next para. As such, comma, it is argued that there is no scope of giving any electricity connection to the petitioner. Full stop. That apart, comma, both learned counsel for the WBACDCL and the private respondent point out that the trade license produced by the petitioner had expired long back. Full stop. Learned counsel for the private respondent also relies on certain discrepancies in the names and addresses of the proof of possession, comma, including a purported rent receipt and voter's identity card, comma, to highlight the fact that the petitioner may not be in possession of the property. Full stop. Next para. The very fact that the competent civil court has passed an order of injunction and the same has been affirmed by the miscellaneous appellate court in favor of the
appeal might not state the
no. Subsequently, there's another miscellaneous appeal.
Miscellaneous appeal was hard on contest finally dismissed the misappeal.
Appellate court has finally affirmed the injunction.
Yes.
Comma. কি বললাম বলো তো না বুঝে It cannot be doubted that the petitioner is in occupation of the property. Push stop. The civil court has granted an injunction protecting such possession of the petitioner, comma, although such finding is subject to the final outcome of the suit. Full stop. As of today, comma, thus, comma, it cannot be said that the petitioner is not in occupation of the property, irrespective of the veracity of the documents produced by the petitioner. Full stop. The lawfulness of such possession shall undoubtedly be decided in the suit. Full stop. Next para. Insofar as the WBACDCL is concerned, comma, it has already raised an offer letter, thereby indicating its primary consent to give the electricity connection. Full stop. The WBACDCL poses certain issues comma, insofar as purported requirement of the petitioner to produce certain documents is concerned. Full stop. However, comma, none of the documents which have been insisted upon by the WBSCDCL are required for the following reasons, colon, next para. Way leave permission and proper NOC of landowner cannot, comma, in any event, comma, be obtained in the present case, comma, in view of the pending litigation between the respondent number 4 and the petitioner, comma, who are the landowner and the occupier respectively. Full stop. Next para. Moreover, comma, the language of section 43 of the Electricity Act 2003 does not afford any opportunity for the distribution licensee to insist upon the same, comma, since either an owner or an occupier, comma, in their own rights, comma, can claim electricity connection at a premises. Full stop. Next para. For similar reason, comma, proper land documents are also not required to be produced by the petitioner. Full stop. Next para. Learned counsel for the WBSCDCL seeks to clarify that by land documents, the WBSCDCL meant tenancy agreement, which is also not required at all, comma, since it is not for the distribution licensee to decide whether a petitioner is a tenant or even is in lawful occupation of the property, as it is well settled that a person in settled possession of a property is entitled to get electricity connection. Full stop. Next para. Insofar as valid trade license is concerned, comma, the justification for so asking of the WBSCDCL is that the connection sought is a commercial connection. Full stop. However, comma, it is seen that at one point of time, the petitioner had a trade license, full stop, irrespective of the fact that the petitioner has or has not a current trade license, comma, it may very well be that a person seeking to establish a business stroke shop stroke trade, comma, for such purpose, comma, seeks to have a commercial connection, upon getting which the said person shall commence the business. Full stop. It is not the lookout of the distribution licensee to ascertain whether there is an already running business merely for the purpose of giving a commercial connection to a person. Full stop. Next para. What the distribution license is to ascertain is that the petitioner is in occupation of the property, which in the present case has been held to be the case. Full stop. Next para. Thus, comma, the insistence of the distribution licensee on the documents as indicated in the written communication filed in court today are of no relevance. Full stop. Next para. Accordingly, WPA number 9265 of 2024 is allowed on contest, directing the WBSCDCL to give electricity connection to the petitioner at the premises in question within a fortnight from date or from the compliance of formalities, comma, whichever is later. Full stop. In the event any resistance or obstruction is offered by the private respondent in doing so, comma, the WBSCDCL personnel shall be at liberty to approach respondent number 3, the inspector in charge of the Contai police station, who, comma, upon communication of a server copy of this order, comma, shall grant such assistance to the WBSCDCL personnel at the cost of the petitioners, comma, if necessary, removing any padlock or other hindrance while doing so. Full stop. It is, comma, however, comma, made clear that nothing in this order shall prejudice the rights and contentions of the parties in the pending civil suit and or create any special right or equity in favor of the petitioner, which the petitioner otherwise does not have in law. No address to cost, urgent certified copies. This also applies to the validity of your business, because you may or may not have a trade license. Merely by getting the connection, you cannot say that you have a right to run the business. That's why not create a special right, not only vis-a-vis him, vis-a-vis the law also.
I'm being led by Mr. Mukherjee, my lord.
Mr. Mukherjee is there also. You are grateful to Mr. Mukherjee or to the court? If you are grateful to Mr. Mukherjee, I'll dismiss. Okay. Next matter.
Number 15.
Yes, Mr. Halda, what is it?
I'm for the petition, Lordship. Lordship, connection.
Mr. Mukherjee for the.
connection for submersible pump, Lordship.
Yes.
Application made. Thereafter, no steps have been taken, Lordship. Suit certificate is also there.
Said this, that no steps taken, this petition is liable to be dismissed because
Why?
in his presence, inspection has been done. Meter room has not been constructed. And now he is
will
saying,
construct within 2
now
days,
kindly see.
Hold another inspection, Mr. Mukherjee.
Within 2 days,
Let him complete and intimate us, then we will make inspection.
You have completed.
Not yet.
Within 2 to 3 days, we will complete.
Well, learned counsel for the petitioner alleges that the petitioner applied for electricity connection to operate a submersible pump, but the same has not been given by the WBSEDCL, which is refuted by learned counsel for the WBSEDCL. Full The latter submits that the WBSEDCL does not have in principle any objection to give the connection. Semicolon, however, comma, the petitioner has not yet constructed a meter room for which such connection cannot be given. Full stop. Next para. The learned counsel for the petitioner, comma, on instruction, comma, submits that the petitioner shall construct such meter room within 2 days. Full stop. Accordingly, WPA 9274 of 2024 is disposed of by directing the petitioner to construct a meter room and intimate the completion of such construction in writing to the WBSEDCL. Full stop. Upon such communication and upon the petitioner complying with all formalities, comma, the WBSEDCL shall, comma, within a fortnight from the date out of the above two, which is later, comma, give such connection to the petitioner by acting on a server copy of this order.
Only thing in this particular case,
No address to cost, certain certificate.
15 days not possible because 4 pole has to be installed.
Very
He
well.
has to pay the money.
Within 4 weeks. Compliance of formalities includes whatever.
Grateful. Including
Whichever is later, his compliance of formalities and
kindly clarify
what?
that. Matter. Upon compliance of all formalities within 4 weeks, because not if he don't pay the money,
Mr. Mukherjee, what I have stated is he will comply with the formalities, construct the meter room. Whichever is later, within 4 weeks from that date, within 4 weeks from the above, whichever is later out of the above two are, one is construction of meter room, other is compliance of formalities.
Grateful.
Next.
Item number 16.
The private respondent.
Yes.
Lordship, petitioners are the tenant lordship applied for domestic connection. CSC authority could not make the inspection due to the.
You agree, Mr. Mukherjee? Yes. What?
The landlady is objecting, lordship.
Yeah, you are the landlady.
Yes, my lord.
What is your
My lord,
objection?
Kindly come to page number 9. They are illegally occupying the premises. They have annexed the rent receipt of 2015. Not how, for this last 10 years, they managed to survive without electricity. They were, my lord, using electricity without any, my lord, authorized mean. Now, my lord, what happened? When we have issued in February the eviction notice, now they need something on black and white because they have nothing in their support to show their premises before the civil court.
You issued eviction notice to a person not in possession.
No, my lord, I'm not disputing his possession. What I am saying is,
If you are not disputing his possession,
but
then
my lord,
section 43 comes in.
my lord, mention it that this will.
So why are you asking how was he residing there? You know that better.
They, my lord, using electricity by illegal means, by hooking, my lord. Now they are.
That is neither not german for this.
Since I have issued.
Why didn't you complain then to the?
I have made several complaints, and now due to my intervention, they have now applied for after 10 years.
The petitioner claims to be a tenant in respect of the property in subject property.
Three petitioners.
Petitioners claim to be the tenants in respect of the subject property and seek electricity connection, which according to the petitioners could not be given by the CSC Limited due to obstruction by the private respondent, stroke landlady. Bishop Leonard, sorry, yes?
The board was locked. The meter board was locked.
Inspection could not be.
No.
Leonard Counsel for the CSC Limited submits that even inspection could not be held since the meter board room was locked. Full stop. Next para, Leonard Counsel appearing for the private respondent stroke landlady submits that the landlady raises the question as to how the petitioner was living in the property for almost 10 years since a rent receipt of August 2015 has been annexed to the writ petition, whereas according to the petitioner has been living without electricity. Full stop. It is contended that such facts themselves indicate that the petitioner was using electricity in an unauthorized manner throughout. Full stop. Next para, it is contended that only after the landlady issued an eviction notice to the petitioners did the petitioners, comma, to create some sort of evidence, comma, apply for electricity connection. Full stop. Be that as it may, comma, the law is very specific as embodied in section 43 of the Electricity Act 2003 that anybody in settled possession of a property is entitled to get electricity connection in the capacity of an occupier, comma, irrespective of the lawfulness of such occupation. Full stop. In the event the private respondent landlady has any objection as to the unauthorized use of electricity, comma, it was all along open to the landlady to pursue her complaints, to make complaints and pursue the same before the distribution licensee. Full stop. However, comma, such allegations are irrelevant for the present purpose. Full stop. Next para. Having held above that the petitioner is entitled to electricity in the capacity of an occupant, comma, it is the incumbent duty of the distribution licensee to give such connection, comma, which was thwarted due to obstruction by the private respondent. Full stop. Accordingly, WPA 9471 of 2024 is allowed on contest, directing the CSC Limited to hold an inspection at the premises to ascertain the feasibility of giving electricity connection to the petitioner in the petitioners in their name at the existing meter board position of the premises. Full stop. Such inspection shall be held within a week from date. Full stop. Upon such inspection, comma, as an if found feasible, comma, the CSC Limited shall, comma, within 3 days thereafter, comma, raise an offer letter. Full stop. Upon the petitioners complying with the formalities, comma, electricity connection shall be given to the petitioners by the CSC Limited within a further fortnight from such compliance. Full stop. On either of the occasions, comma, inspection or giving connection, comma, if any hindrance is put up or obstruction is raised or padlock is affixed by the private respondent and or her men and agents, comma, it will be open to the CSC personnel to approach respondent number 3, the officer in charge of the Golabari police station, for police assistance, which will be granted by respondent number 3 by acting on a server copy of this order at the cost of the petitioner, comma, removing all hindrances, comma, if any, comma, in the process to assist the CSC personnel in holding such inspection and giving such connection to the petitioner. Full stop. No arrest to cause urgency.
My lord, only that line that this electricity connection would not give any premium to their civil rights. That, my lord, in
Very
another
well.
matter.
It is made clear that nothing in this order or the electricity connection, comma, as and when given to the petitioner shall confer any special right or equity on the petitioner which the petitioner does not otherwise have in law.
Open a padlock. Otherwise,
Padlock, hindrance, everything. Put in a different construction for variety. Yes.
Arena number 17.
Yes.
Third, I appear for the petition.
Yes. What is the matter, please?
Item number 46 also similar matter. Same matter.
17 and 46.
46
Relates
similar
to
matter.
requisitioning of cooperative bank employees for the ensuing
It is the same parties.
No,
It is the same party.
different
Against the election
cooperative against the election. Different
So let me decide this first, then whenever it is taken up. Yes. What is the matter?
on challenge on 3 grounds. First, there is no separate requisition. The direct notice issued is for appointment. Will you kindly see page 46.
No, Election Commission of India is the necessary.
Necessary.
Yeah.
Kindly see start persons of section 26 of the representation of the
No, which page?
46.
Yes, 46.
In pursuance of section 26 of the Representation of the People Act 1951, I do hereby appoint the officers specified below. Now, this is an appointment which is being issued by the District Election Officer Malda. Now, the section 159 of the Representation of People's Act 1951 clearly specifies that requisition and appointment are dealt with under 2 different sections. Appointments can be given by this district election officer, but the requisition has to be made by the chief electoral officer of a state. Section 159. Staff of certain authorities to be made available. The regional commission appointed under clause 4 of Article 324 or the Chief Electoral Officer of the state. And whether there is no provision for delegation.
No, you say 159 has not been complied with.
My lord, because the requisitioning has to be made either of the by these two officers. The Chief Electoral Officer.
Only after that 26 can come.
Only after that 26 can come.
What do you say to this?
And
Yes,
this is
anything else?
one. Yes,
Yeah.
this
Good.
is the first. Second part is if the notice is to be read, section 159 cannot be implemented or invoked by this officer concerned because he has no power. That apart, my lord, kindly seek section 159 2 subsection 4, by virtue of which I have been made my services have been asked for. It deals with specific statutory, kindly sees the word use by an established under, I do not come under the first three, only the fourth, by and established under central, state or provincial statute. Mine is a cooperative bank which was established pre-independence. So I have not been established under any statute. I have been rendering my functions time to time. I have,
or which is controlled or financed wholly or substantially by funds provided by
that has been decided with by your lordship. I have attached the order.
What has been decided by me?
With regard to the state, whether I will come under the other authority or my financial control or that, your lordship's order is at
for this is your cooperative
my
bank?
Cooperative, page 52. With regard to the panchayat elections, this specific entity had come up before your lordship.
You don't come under that?
No, I don't come. That has been held 52.
This has not been challenged.
It has not been challenged. Attend finally.
Mr. Shamto, what do you say to these 2 points?
My lord, with regard to, my lord, first I will say, my lord, with regard to cooperative, West Bengal Cooperative Society Act, my lord, because they are governed by West Bengal Society Cooperatives Act, my lord, with section 10, my lord. I will just hand over the book to your lordship after I
No, regarding the first point first, 159 has not been complied this thing.
159.4, my lord. I am just coming 159.4 because they are governed by 159.4 because they are financed, my lord.
Section 10?
Because in your lordship's direction.
Section 10 of this?
Yes, my lord. Cooperatives.
Societies Act?
Yes, my lord.
You are relying on section 10?
Section 10, my lord. Every officer of a cooperative society shall be deemed to be a public servant within the meaning of section 21 of the Indian Penal Code, 1860, my lord.
This is for a different purpose.
No, my lord.
Section 21 of IPC.
My lord, this bank, my lord, registered under West Bengal Cooperative Society Act 2006, my lord.
Section 21 of IPC, let us see.
I am handing it over, my lord.
What is there? Just read out for me. What is the purpose of section 21?
My lord, it is to public servant, my lord. The word public servant denotes a person falling under any of the descriptions herein after following, namely, my lord, skipping everything, I am coming to 11.
Yes, but
every person, my lord, I am just reading it.
Yes.
Every person who holds any office in virtue of which he is empowered to prepare, publish, maintain, or revise an electoral roll, or to conduct an election, or part of an election. But if they are public servant, they are coming under this, my lord, clause.
I am not public servant.
The section 159.4 does not speak of public servant.
That is separate, my lord. That is coming, my lord. But with this section 10, because this bank, my lord, are registered under West Bengal Cooperative Society Act 2006, my lord.
Right.
Whatever they are in the 2006, my lord, they are duty bound to do that, my lord. Section 10 says that they are public servant, my lord. And that relates to section 21 of this Indian Penal Code, my lord, where it says that they have to do the election duty, my lord. It is a first submission, my lord.
What about the judgment they are citing?
So has dealt with each and every issues. Specific with regard to this.
But your lordship has dealt with that they are not financially approved, my lord. I will show that they are financially approved, my lord. With another judgment of Bombay High Court, I will show, my lord, they are financially
But Calcutta
approved.
High Court is binding on me. If you have not challenged, why didn't you challenge this?
But this is against State Election Commission, my lord.
Oh.
My lord, they do not, in State Election Commission, my lord, they do not have this section 159.4, my lord. If you kindly, lordship, my lord, if I go through this 159.4, my lord, any other institution, concern or undertaking which is established by or under a central, provincial or state act, which is controlled or financed wholly or substantially by funds provided directly or indirectly by the central government or state government, my lord. My lord, in your lordship's direction, my lord, your lordship has told that the West Bengal government have share in it, my lord. My lord, in your lordship's order, my lord, at para 6. As page 53, my lord, at para 6.
Yes.
Apart from citing provisions of West Bengal Cooperative Societies Rule 2011, hereinafter referred to as the 2011 rules, it is disclosed in the bank's report that as per the audited financial statements of bank as on March 31, 2023,
The government of West Bengal holds 55,480 shares of rupees 100 each. My lord, they have their funds over there, my lord, and also, my lord, from central government, I will show a.
But it is not controlled because other shareholders together have more.
Yes,
That
my lord.
was the
But
next sentence.
yes, my lord. But here, my lord. Yes, my lord. That have gone, my lord. But they are, my lord, in state commission. They do not have this section, my lord.
Nothing corresponding to this 4, Roman 4.
Yes, my
In
lord.
the State Act, there is nothing corresponding
Yes,
to
my lord. And my lord, moreover, my lord, moreover, I will show one printout from there in Google. From NABARD, I have taken, my lord. Central government is giving funds by through NABARD to this cooperative bank, my
that
lord.
question I cannot reopen unless this order is set aside.
No, my lord, that is a state.
But even otherwise, you come within, because you can argue that they come within this act.
Yes, my
They
lord.
operate within this.
But this is, my lord, state commission, my lord. They do not have this 159.4, my lord.
That is a valid argument. Yes, I've recorded that.
My lord, because my lord, there is also central government is giving helping, my lord, to NABARD,
Oh,
my lord.
central government is.
Central government one, indirectly or directly, my lord. My lord, I will just.
No, language is not directly or indirectly. Language is.
Yes, my lord. Directly or indirectly.
No, that is
Funds
not.
provided directly or indirectly by the central government or state government, my lord. My lord, kindly come 159.4, my lord.
No, which is controlled or financed.
Yes, my lord.
Wholly or substantially.
Well, thereafter.
Thereafter comes thereafter.
Yes, my lord.
Therein before, it has to be wholly or substantially run. Directly, indirectly, from some other source, from some hidden source under the table, that is different.
They are taking.
Wholly or substantially is the key word, Mr. Samantu. If it is not run wholly or substantially, it was held there, the number of shares was held. And it was observed clearly that this
They
is
are
not
also
wholly.
taking help from central government, my lord, government of India to NABARD, my lord.
No, that too not wholly or substantially.
But my lord, provided directly or indirectly central government or state government.
Oh, your obsession with directly or substantially will kill your case, Mr. Samantu.
Thereafter, my lord, I will show one judgment which relates on that, my lord. Kindly
I don't want to see any judgment. First, explain the statute. I'll go to judgments later. The statute says wholly or are you wholly or substantially funding them?
No.
Can you?
No.
Under the act even?
No.
What are you saying?
Well,
Wholly and substantially, that is the crux of the section. That is the key section. Key word of the section. Funds directly or indirectly, funds is important. Directly, indirectly, I'm not bothered with that even. Maybe indirect.
But state government is having
But
share, my
funds
lord.
have to be given. Shares is not sufficient, Mr. Samanto. It's very difficult to penetrate your head. I must say this. Wholly or substantially, do you even understand the meaning of these two words? Very difficult, even with a hammer probe. I'm repeatedly going on saying you're wasting time. Show me that wholly or substantially you are running it, and I'll go with you. So where are you going to directly, indirectly funding under the table? Why? This is not even German. We have to see whether it's wholly or substantially run by you. I'm not on the funding at all, the mode of funding. You can even fund by electoral bonds. I don't have any qualms on that. But it has to be wholly or substantially run by you. That is the statute, your own statute. It's a central legislation. So then, how do you overcome that? Tell me that. Argue on law, not on your obsessions. Mr. Samant, you are missing out your best argument. It's or, there's an or financed wholly or substantially. Argue on his submission. Your learned friend argued that these were established previously, prior to independence. And your argument is the preceding the or is that which is established by or under a central provision or state act. Argue on that whether it can be said to be established under this act. Let us see what the scope of this act. You are not arguing even on that. You have not even prepared on that. Is there any compulsion for them to register under the new act or something like that, akin to that?
That I do not know.
To function as a cooperative society, I need to get registered under this.
Yes.
Need to.
No, I'll come back to you. I'll come back to you on that. I was expecting Mr. Samantu to point that out. Anyway, what about the first point? Section 159 and 26? 159 has not been exhausted.
26, my lord, chief electoral official can appoint, my lord.
Who denies that, Mr. Samantu? Who denies that? He's not denying that.
But
He's saying that has to be, before that, there has to be a requisition under section 159. Then only the appointment takes place.
yes, my lord.
Here he's saying there has not been any requisition under 159 preceding the appointment under section 26.
But then that in this case that I have to take instruction because whether they requisition or
Why
not.
didn't you take instruction? When was the copy served? You are arguing, you are appearing before a high court of a state. You are saying that I have to take instruction on that when you are on the verge of losing the case. Why didn't you take instruction in the first place? You are representing the Election Commission of India, Mr. Samantu. You should be proud of that. You understand the responsibility for that. If the court has to do everything for you, then why you appear? Let me come back to you. Yes, you satisfy me from the preamble of the act, the scope, the purpose of the act.
Lord, I do not have.
But you have to have a registration under this 2006 Act also.
Yes, I have a registration, but the
Then why
words,
can't it be put under this clause 4?
the specific word, the term
Yes,
used
why should
is
we interpret that?
established. Well, it has been interpreted earlier by courts. Well, I have the judgments I have not cited. It has been, the law is settled. Established by or under is different from getting registered for the purpose of compliance.
That has been held by which court?
Well, Lord, in Dalco Engineering by the Supreme Court, that has been relied upon.
Please cite those.
My
Please
lord.
cite those. Because that is one of the facets here.
I have.
Yes, yes. Yes, yes.
Kindly takes this Gujarat High Court Division Bench judgment, which has dealt with the specific issue of cooperative societies and this issue.
Which paragraph?
Lord, paragraphs 4.4.
Give a copy to him.
My lord, I say.
Because I'm hearing you on a judgment, I'll hear him also. On this. 4.4 at page 9. 7. These are the facts. Thereafter, the ratio starts from 7.1. No, this is a different question. Control or finance.
Well, kindly see.
This is on the second facet.
No, 4.6 with regard to this, the words central by established. Lord, kindly.
No, where is it? Adjudication on that.
Lord, these are the facts. I have stating the facts. This.
No, come to the adjudication.
Ratio starts from 7.1.
7.1 is different on total control.
7.
That's on the other issue.
Lord, kindly see 7.2, somewhat considered. Lord,
What similar question? Which is the question formulated is, the first question is whether the petitioner number 1 district cooperative can be said to be an institution, concern or undertaking which is controlled or financially. There is a second limb of 4. Where is the first limb? Adjudication.
Lord, with regard to this, Lord,
we are not discussing even that because you have cited one judgment of this court on that.
My lord. Specific paragraphs of Dalco that has been.
Both of you come properly prepared on this. Mr. Samantu take instruction on whether 159 has been complied with. Because if it has been complied with, then his first point goes.
Paragraphs.
Arguments were sought to be advanced on the matter. However, some lack of preparation on the part of learned counsel for the ECI is marked. To enable learned counsel to come properly prepared, let the matter stand over till tomorrow when it will be listed under the same heading. বইগুলো যার যার বই তাকে ফেরত।
Let it be day after tomorrow, my lord.
Very well, day after adjourn till day after tomorrow. Give your name. Na eta diye. 46 very well. No, 46 I'll keep along with this day after tomorrow. 46 when if it is called on, please just have somebody mention. I'll keep it with 17. I cannot take it out of turn. I'll take it when it is called on. If I can't reach it in any event, have it mentioned tomorrow so that I can club it with. আর একটা যদি 46টা আজকে রিচ করতে পারবো না মনে হয় 46টা পরশুদিন 17 এর সঙ্গে থাকবে। Mr. Samantu, you are appearing in 46 also?
Yes, my lord.
So this will appear, 46 will appear along with 17 on day after tomorrow. Please come prepared on that day. And cite your judgments, I'll hear you afresh. Cite your judgments and complete your arguments, then I'll go on to him.
Note the page numbers.
But that was not the point. 7.1 is not your paragraph.
It comes after 7.9. I have found it out later.
Start from the after on the next date. Yes. Next.
Item number 18.
Mr. Samanta, please don't mind. This is only for your benefit. Come prepared on the matter. I have more expectations. That is why I said so much. If I did not have any expectation, I would not have said anything. That would be easier for me. Yes, please. What is the matter?
What your lordship noticed in the order, my lord, that is.
Well, I'll do something. একটা বলেছি যে ill prepared. এটা কেটে দাও. What is your other side? However, it appears that some other facets of the matter are required to be clarified by the Election Commission of India. Bas, please inform your other side. I've made that change. Yes.
I'm grateful, my lord.
Yes. What is the matter? Sorry.
Reverse shifting of starter house. That's starter house.
You want a removal of a slaughter house.
Nothing more.
My lord, I need to say something about this matter.
You are the owner of the slaughter house.
No, he's my
You have to say what? Your leader is there. What is happening? Your senior is not paying you. If I have to say anything on that, you can submit. Otherwise, your senior is there. Yes.
I'm for the private respondents, my lord.
Slaughterhouse owner.
Slaughterhouse, my lord.
Yes. Why are you slaughtering?
Takes up, my lord, my opposition, my lord.
My lord, kindly look at the last order first. Last order.
My lord, kindly takes up, my lord, my.
What was the last order? Let me. I cannot bear the suspense. I'll look into the last order, then I'll come to it.
Entirely the opinion of the state on which the outcome of the writ petition hinges.
Who is for the state? State is not appearing today also. Slaughterhouse, you will defend yourself.
My lord, so far, my lord, my slaughterhouse is concerned, my lord, kindly takes up my opposition. My lord, and my lord, three aspects are there, my lord. I'm running it on, my lord, on a, my lord.
The state has not filed in opposition also.
No.
Then I'll have to hear you. Yes. Opposition?
My opposition, my lord, kindly sees, my lord. First, my lord, takes up page number 5. There is a written receipt issued by, my lord, the predecessor of the petitioner. Firstly. Secondly, my lord, kindly takes up, my lord.
No, his allegation is different, not regarding your legality of your position. Your allegation is what? That it's near to some residential. What is your allegation?
Public place.
Public place. What is the law on that? Cite the no law.
No, law is there.
What is the law? Take your seat. Let him argue first. Yes. Slaughterhouse near a public place. Why is it barred? Under the law, where is it barred?
Some criteria is there.
You know the law?
Well, subject to correction, my lord, this can be a subject matter of the public interest litigation, my lord. No. My lord, there is no express, my lord, my lord. So far, my lord, my lord, knowledge goes, my lord, there is no express law, my lord, which bars the slaughterhouse, my lord, in a particular place, my lord, if it has got all the, my lord, other requisites. That
No, right to lead a proper life, Article 21 vaguely comes in. It's just open slaughterhouse. There are bars, there are laws which debar open slaughterhouse.
That is
this is not an open slaughterhouse.
Certainly not.
Unless you have a legal right, you can establish a legal right. Why should you get a... What is infringed here? Let me see your writ petition at least. There has to be a legal right or fundamental right which has been infringed. What is that right? You are a member of the public or you are residing in that area?
I am residing here.
They are running the slaughterhouse for quite some time.
Yes, no doubt about it.
So,
kindly paragraph 2 first.
Paragraph?
2 of my writ petition.
Yes.
Everything is precise there.
Please place it. Odor pollution, go before the Pollution Control Board.
One after another.
Yes. Slaughtering cow in public area, which is banned by your constitution in public places. Which article of the constitution? There is a ban. I know, but I vaguely know. What is the law on that? There are laws on that. Openly, you cannot run a slaughterhouse.
There is a Hindu temple, my lord. In front of the Hindu temple, a slaughterhouse can be gone.
Secular, still secular. Secular is still there. Slaughterhouse, people want to eat cows, they can.
There is some difference, my lord.
What is the difference?
Yes, slaughterhouse is maintained, cleanliness, pollution, and my lord, one after another, pollution.
If it's a closed slaughterhouse, within the slaughterhouse, if it happens,
Temple is closed to slaughterhouse.
if it is open slaughterhouse, it offends your senses, definitely. Definitely.
It is very
You don't want a bloody scene on the street.
I think, my
No.
lord,
But if it's a closed
I think
slaughterhouse,
subject to lordship correction, Panchayat will appear before your lordship. He decide who told you it is the existence of slaughterhouse. How what type of existence is of the slaughterhouse there?
you are a cow vigilante. Yes.
50, 60 cows is slaughtered each and every day.
Who sells them to them? Probably the priests of the temple sell those cows when they lose their efficacy. Otherwise,
but a person.
More Hindus sell cows than Muslims. Do you have any idea on that, sir?
I am not a Muslim, lord. I cannot. What's the idea?
The Hindu temple you are saying, that's why I told you.
Yes. In front of a Hindu temple, it is permissible, lord. Can you tell me?
Why not? In front of Hindu temple.
In front of the Hindu temple.
So why did you tolerate it for so long? What is the recent cause of action for this writ petition? How long is it running? Let me see.
14 years.
14 years you have tolerated.
Each and every day that
One of us would have been complete by now.
each and
14 years you have tolerated for what is the difficulty now?
But after
You have said there is odor, there is stench. Valid ground. Move the pollution control board if you feel there is a violation of pollution norms. Definitely.
Is there a license?
You cannot fish out evidence like this.
Is there a
before
license?
writ court.
Is there a certificate?
I don't know. Why are you asking me?
No. I am asking my landlord.
These are rhetorical questions.
Sorry.
Is there a legal right which is being infringed? This I am asking to you.
But there is
Show me your legal right. Show me that it has been infringed. I'll slaughter the slaughterhouse.
If there any slaughterhouse,
But you have to show me a legal right.
I'm telling you, Lord, if there is slaughterhouse, my lord, that should be a license. That should be a certificate of doctor or health department.
Could be, but why should the writ court look into that even? It's a municipal area or the Kolkata Municipal Corporation?
No,
KMC area?
Panchayat area.
Panchayat area.
But page 9 of my opposition, my lord.
You couch it as a police inaction matter, go before the appropriate court. It will be easier for you. You are before a bad court. Gram Panchayat has given permission. Certificate has been issued.
This is not
Look into page 9 of the opposition.
This is nothing for the public. This is not sufficient for running a slaughterhouse.
What is required?
Certificate is required for the health department.
Show me the law of that.
I'm
Yes.
showing
Show me
you-
the law. Yes. Give a copy to him also. Please give a copy to him.
The citation done. I didn't know it about Tomari Act.
This is what I was asking from you.
Yeah.
West Bengal Animal Slaughter Control Act 1950. Yes. Which provision?
Section 4. Section 4. Notwithstanding anything in any other law for the time being in force or any usage to the contrary, no person shall protect any animal unless he has obtained in respect thereof a certificate under subsection 2 or subsection 3 that the animal is fit for slaughter.
So, president of a municipality or a panchayat shomiti, he is showing a certificate of the Gram Panchayat.
Joint certificate is necessary, my lord.
No, or
Joint certificate.
joint certificate with whom?
President of municipality or panchayat samiti, as the case may be, and the veterinary surgeon.
Yes. Right. So it is not there.
No.
So why are you hiding this so long?
No.
Yes. What else? What other law has been violated? So they don't have this certificate under section 4, right? What else?
Animals is over 14 years. So many.
You cannot assess the eye. Sorry, I cannot assess the age of the animal by seeing.
No, no.
Very difficult. Even humans, I cannot. So animals is very difficult to guess the age of a cow.
This is the main portion. Certificate is necessary.
Very difficult.
Without certificate.
There are penalties. Let us see the penalties here. Punishable with imprisonment.
Yes. Section 7 million.
No. What you have to do is you have to approach the president of a municipality or a panchayat samiti, here panchayat samiti, because section 6 of this act says, for the purposes of enforcing provisions of this act, president of a municipality or a panchayat samiti, as the case may be, or veterinary surgeon, whoever gives the certificate, in writing in this behalf, shall have power to enter and inspect any premises.
What inspection?
So approach before them those authorities.
Made in several times in several applications.
Where is the representation? Show me that.
লেখা পড়া যাবে না।
Number 12, 13, 13A.
13A. 14, page 14.
11 onwards, in fact. No, 11 is BDO. The BDO is not the authority. This BMOH, it is a veterinary surgeon.
Veterinary. They are two pradhan, page 14.
Yes. What is your answer to the violation of this statute? Because it has to be by a veterinary surgeon jointly signed, as well as. What are your documents? Let us see page 7, page.
Application made out the that is a slaughterhouse, not my lord, the quality of the animals, those are being slaughtered.
No, that is not there. But they are saying you are running illegally. No, they are saying that, and Mr. Your learned friend is just, relying on section 4 of the act. See section 4, subsection 2.
Of slaughter without
2, subsection 2.
A particular animal is fit for slaughter. That is one of the
2.
I'm on 2 minus 4. Well, the president of a municipality or a panchayat samiti and the case may be, and the veterinary surgeon may issue a certificate under their joint signature that an animal is fit for slaughter if they are of opinion which shall be recorded that the animal is over 14 years of age and unfit for work or breeding of the animal.
Another aspect will do.
I'm on 2 minus 4.
You are right.
And
yes.
the animal become permanently incapacitated from work or breeding due to injury.
So he has brought nothing on record to show that you are violating this.
That this is
Yes.
So the restriction has been made out by the against the slaughterhouse
Itself.
my lord, that the house is not out. The slaughterhouse cannot run. Nothing on record, my lord, to show my lord that particular animals that those are being slaughtered, those are my lord feet or my lord this. Kindly take some of the repetition. Kindly see my lord what the allegations.
Achha, what about this running before a Hindu temple school and all these things? No, what is your statement on that?
So far, my instruction goes, my lord, it has been running for a long time.
Not your instruction. What is your affidavit?
As Hindu temple is there, my lord.
Issue is there.
The statement in your opposition. How have you dealt with it? Have they stated it in their writ petition?
Kindly cease my lord the
Pollution you have dealt with 50 years running.
kindly cease my lord the allegations those have been kindly cease my lord the allegations those have been made, my lord. The stench, my lord,
Yes, all on pollution and stench on.
pollution stench, my lord, those have been dealt with, my lord. The subject, my lord, correction, my lord, slaughterhouse, my lord.
Partition matter anywhere matter the electricity product matter it is any product of the any worker. The general and very big.
Yes, why have you not dealt with these allegations at page 14 onwards? What is this? एक minute down. Further. What is this? What is this? What are you handing up? Affidavit in opposition. Have you given copies to all? You're giving now. How are they supposed to use a reply to this? Yes, Mr. Chatterjee, how are they supposed to give a reply? As a last chance, it was directed, you are directed to file affidavit in opposition. That was on 8th of April. Then, today we are on 22nd, 23rd of April. Are correct. Why haven't you taken steps? Correct because of the elections. Because of the elections, those are correct. And you have not gone through the affidavit, obviously. If this is the standard of representation, Mr. Chatterjee, of the Election Commission and the state, I mean, I am dumbstruck. I am seriously telling you, I am dumbstruck. How do you expect that the state or the Election Commission will win any litigation in any court of law? And then it is on the court that they are biased this way or that way.
I cannot put my signature on the affidavit. So with that senior
Are you ready with the affidavit? You are representing the state, Mr. Chatterjee. What is written in the affidavit? Tell me. Yes, page 8 of their opposition.
Paragraph 6, kindly look at.
No, it is in your favor. I'll hear the other side. Yes, page 8. Please come to page 8. Shoghoshana Patra. It's apparently in your handwriting. Yes, I think you should deal with this. The petitioner's contention is that the private respondent has been running a slaughterhouse which offends the constitutional provisions and the law. Full stop. Learned counsel for the petitioner relies on section 4 within bracket 2 of the West Bengal Animal Slaughter Control Act, 1950, which provides that the president of a municipality or a panchayat samiti, as the case may be, and the veterinary surgeon may issue a certificate under their joint signatures that an animal is fit for slaughter if they are of the opinion on the yardsticks as stipulated in the said section. Full stop. Next para, it is submitted that the slaughterhouse is running without a valid license. Full stop. Next para, learned counsel appearing for the private respondent denies the allegation and places reliance on the annexures to the affidavit in opposition filed by the said respondent. Full stop. In the affidavit in opposition, the rent receipts in respect of the slaughterhouse have been annexed, as have been certificate issued by the Salar Gram Panchayat permitting the petitioner to run the said slaughterhouse. Full stop. Next para. The petitioner has also annexed other documents to show that the petitioner has been paying the due taxes for running the slaughterhouse. Sorry, the petitioner, private respondent. It is private respondent. Next para. After substantial hearing of the matter, comma, learned counsel appearing for the respondent number 5 appears and files an affidavit in the form of a report, comma, a copy of which has not been served on the learned advocates appearing for the other parties. Full stop. It is seen from the order dated April 8, 2024 that a last chance was given to the respondents to file their affidavits in opposition. Full stop. It was expected that copies of the affidavit should have been handed over to the learned counsel appearing for the petitioner and the other respondent. Full stop. Be that as it may, comma, copies are handed over here and now. Full stop. Since the purport of the affidavit in the form of a report filed by respondent number 5 today goes primarily against the private respondent, comma, on the prayer of learned counsel for the private respondent, comma, the said respondent is granted liberty to file a rejoinder to the report within a week from date upon service of prior copies of the same before the learned advocates appearing for the state as well as the petitioners. Full stop. The matter shall be taken up for hearing under the same heading on April 30, 2024. No, this much.
Grateful.
But your license has probably expired. Look into that also.
I'll just go ahead.
আরেকটা ছোট দেখে দাও দেখি।
Item number 19.
My 20, make it 29.
30th.
30.
Yes, Mr. Chakraborty, this will take some time. What is the matter?
But I appeal for WBCDCL also.
For the added Lord, I have constructed a building. I applied for electricity connection. ACDCL says that you have to install a transformer. I applied to the municipality. The municipality is the owner of the road in front of the house. They granted me permission to install transformer. On that, Lord, the quotation was raised. I deposited 10 lakhs. When they came to install, Lord, the ex-councillor of the municipality and some local persons, they, Lord, stopped them from doing the job. Now, my Lord, at that stage, I am before your lordships.
Where is the permission of the municipality?
Yes, kindly take, my Lord, page 22. Page 22. This is the permission of the municipality. It is their road. 23, the quotation raised.
Yes, objection by the private respondent.
Yes, that
for the
Lordship
private
will-
respondent.
Lordship has seen, and the added respondent, Lordship has seen the permission letter.
Yes.
Lordship, the permission was specifically that the movement of the vehicles or pedestrian is not disturbed. Lordship, what has happened, I've taken specific instruction, I've taken the photograph. Lordship, you kindly have a look. They have dug up the entire pavement.
Sure, give me the photograph.
Lordship will kindly have a look. And Lordship, on that day, there was no person of the municipality or the distribution company there for
No.
us to make the grievance that do not dug up the pavement.
How being an ex-councillor, you are involved in the property. What is your right?
I am a person who's there. The issues happened with everyone around. My name has been included because I was one of the person in the mob.
Page 26.
Lordship, kindly.
He is no way connected to your
No,
property.
while installing the transformer, this happens everywhere, wherever there is a.
The thing is, the shops, now it is not only me who was there, Lordship. There were
How
other
soon can you install the transformer?
What is your right?
Lordship, we're ready and willing because our person.
How soon can you do that? It has already been dug up.
Yes.
Lordship, kindly give us sense because
2-3 days.
my instruction is this will only for the resident we are not doing. If there is no Milord,
How soon can you finish it?
that Milord, that exactly from my
the
mouth
cost
I
of
cannot
the
say.
one is just one request.
Within a week it
Upon
can be
your
done,
Lordship.
Lordship.
Lordship, may I beseech upon you? I have taken instruction. My client has said there's another place where it can be done. Where the pavement would
Political
be
man, how are you
All I'm
involved
saying
in
is,
the
Lordship,
property?
let the municipality just make one
Incal
inspection
করেছে।
No.
to decide as to if there's another.
You have no locus standi.
Yes.
Lordship, I am not the only person there, Lordship. My name has been used. There are other respondents also. They are the owners of the shops there. They will also have a problem, Lordship.
Page 26, his name appears in the letter.
Lordship,
Page 26.
and the averment is I am not the only person who's making a spoken.
You are nobody, my brother. You are nobody.
I was there with a few other people who are also owners of the shop there in Lordship.
Lord, they will install some.
Learned counsel for the petitioner contends that the petitioner sought for electricity supply to his premises, a service connection for getting electricity supply to his premises. Although a quotation was raised, comma, a transformer was required to be installed for giving such electricity. The petitioner obtains obtained permission from the local municipality, comma, issued by the chairman of the Rishra municipality, comma, for installation of such transformer on municipal land, comma, subject to normal movement of vehicles and pedestrians not being disturbed. Push up next para. However, comma, due to obstruction raised by the added respondent, who is the local councillor, comma, the achha.
Not even present.
Who is
Not even present.
who is an ex-councillor of the locality, comma, the installation could not be completed. Push up next para. Learned council for the added respondent hands over a photograph indicating that the footpath in the vicinity has been dug up for installation of the transformer. Push up, it is submitted that by installation of the transformer, comma, the local shopkeepers shall be affected financially. Push up, it is submitted that the added respondent has only taken up the cudgel for such shop owners and the people in the vicinity. Push up, it is submitted that the WBACDCL may explore alternative locations for installing the transformer. Push up next para. Upon a perusal of the documents, comma, it is clear that the Rishra municipality, comma, which is the local municipality, comma, granted permission for installation of the transformer on municipal land. Pushed up as such, comma, the added respondent, comma, as ex-councillor, comma, does not have any locus standi to put up an obstruction to the same. Pushed up next para. It is to be noted that there is no obstruction raised by the local shopkeepers, comma.
But two of them have made parties. They have been served.
They have admitted the local shopkeepers have raised objection.
No, they have been made party and they have been served. There are not.
Comma, which is worth taking note of within the contemplation of law. Full stop. In any event, comma, the installation is being made on municipal property.
Yes.
And as such, comma, in the event the shopkeepers have any grievance regarding the ingress and egress to their properties being disrupted, comma, the shopkeepers always have the avenue open to approach a civil court in that regard. Full stop. In any event, comma, it is clear from the photograph that the digging work has already been done, and as such, the transformer should be installed at the earliest in order to avoid further public inconvenience. Full stop. Next para. However, comma, it is to be ensured that the WBACDCL installs the transformer keeping in view safety measures as contemplated in law and the WBERC regulations, comma, taking into account the concerns of safety and hazards in the locality while so installing. Full stop. Accordingly, WPA 7842 of 2024 is disposed of by directing the WBACDCL to install the transformer within a week from date. Full stop. It is the WBACDCL shall, comma, while so installing, comma, ensure that due safety measures are taken into consideration insofar as the people in the neighborhood are concerned. Full stop. Moreover, comma, the WBACDCL shall carry on ensuring that the transformer does not pose a public hazard in any manner in the vicinity. Full stop. Next para. Upon such transformer being installed, comma, the WBACDCL shall, comma, within 48 hours thereafter, comma, give electricity connection to the petitioner. Full stop.
Lord, if required, they will take police help. Lord, I have made the
In the
police station a
event
party.
the
Respond number 7.
WBACDCL face any obstruction, comma, it will be open to them to approach the officer in charge.
Rishra police station. Respondent number 7.
Rishra police station, that is respondent number 7 for police assistance, which will be granted by the respondent 7 by acting on a server copy of this order at the cost of the petitioners. Full stop. It is made clear that nothing in this order shall preclude the private respondents and or any other person in the locality from raising objections in the from lodging complaints in the event it is seen that the transformer, comma, when installed, comma, does not adhere to safety norms and legal regulations.
So it is 48 hours, Lordship. 48
No
hours
arrest to cost.
because
You have that liberty, please take that.
instead of 48 hours, can you make it 3 days? Because the poles are to be installed and below line to be drawn.
Okay, 48 hours সেখানে বলেছি within a further week thereafter. connection.
Not only one indulgence, though my learned friend is appearing, but in the writ petition we
The
mentioned,
photograph file to be kept on record.
in the writ petition we mentioned a wrong address. My lord, should we correct it? He is appearing before your lordship, my lord. So, my lord, just to bring to your lordship notice, my lord. And the affidavit of service may be kept with the record.
Grateful, lords.
PM fixed matter item number 49.
Instead of wasting your lordship's valuable time, my lord, we have prepared additional notes of
But
argument.
both sides have advanced very excellent arguments. I mean, I was thinking over the matter.
Yes, sir. Is an additional note of argument.
Yes,
And
yes.
yesterday, my lord, I submitted before your lordship
Right.
that the assignment. I have not received the document. Today I have received the document about the assignment.
Assignment regarding?
My lord, the grantee has assigned this patent.
Oh, that his assignment. Right.
Well, this is his application. This copy is not with your lordship's record.
Additional written notes, আগের দিন কোনো written notes আছে?
And I have referred everything there.
আগের দিন written notes
Yesterday, my lord, yesterday I have filed one written notes of
সেই
argument.
written notes গুলো দিন। সব আলাদা করে করতে হবে তো। একসঙ্গে গেঁথে দেবেন না। অর্ডার গুলো brief as possible, all of you. What else can be done?
I always try.
I'm sacrificing, I mean, some very good arguments for that also, but due to paucity of time. So much has been accumulated already by us. I mean, and these things come in every day. I'm giving the same instruction. Together, orders, in the midst of orders, suddenly written notes. Every 10 minutes, at least I lose 2-3 minutes on this.
Yeah, should I assist them or after the order?
I have tried to assist them also, but to no avail.
I can assist them and
No, Mr. What is it? No use. Nothing will be registered. That will be a one-time assistance only. আপনি বুঝে নিন জিনিসটা।
Yesterday I have handed over. Written notes of argument. Yes. 3-page note. 3-page. My lord I have referred, my lord has considered.
কি লেখা? Caption? কি?
My lord, I have got two, my lord. One yesterday and today I have just now handed over.
Yes.
And today, my lord, I have handed over just now, your lordship, my lord, the
additional
application, my lord, the document, not the application for assignment of the patent by the, my lord, this Kanishka Sinha to Lipika Das Sinha.
Assignment is probably admitted also somewhere in the writ petition.
No.
No,
It is not.
Well, I'll ask Mr.
No, not at all.
So today you have handed over this additional written notes of arguments.
Additional notes and the application for assignment with
this.
Yes. And this is, my lord, the final assignment decision. It is available in the website. He has no right. He has no locus standi. This has been suppressed from you. Not only this amounts to suppression, no locus standi, my lord, misrepresentation, and practically, my lord, fraud on court. And this is, my lord, the agreement your lordship asked my junior to yesterday, my lord. This is a copy of it. Trips.
Okay. All.
And my lord, the judgment, my lord, referred there, my lord, a copy of the judgment.
You have given a copy to him
Yes,
also?
I did.
So,
No.
So I'll just hear. Yes, Mr. Sen. What is your reply?
Mine.
Be short, be precise.
My lord, I
Yes.
am very precise. My lord, my written notes of submission
Thank
with
you.
regard to my learned friend's excellent submission made yesterday.
Yes, Mr. Sinha, what about your assignment?
My lord, with regard to assignment, my lord, I have not deviated my rights. My lord, may I take your lordship to page number? Of my written notes of argument, page number 9.
You must have given a copy to them also.
So, page number 9 of my written notes of argument.
Yes.
My lord, this is the e-register of patent handed over my learned friend also right now. And my name is there as a grantee still. And my wife is the patentee and I am the grantee. We both hold the patent. And my lord, I have granted the assignment to the extent of granting license. My lord, that was recorded in the order dated page number 14 of my written notes. Only to the extent of granting license for registration, in which my learned friend is also part through Union of India.
Page 14 is an order.
My lords, by the learned additional district judge, wherein it is further submitted that now he has granted license to the person as mentioned in the e-register of patents, which was handed over my learned friend, the particulars of which assignees is mentioned in page number 12 to 15 of this instant application, and the concerned state respondents would be allowed to register those assignees, because plaintiff himself granted license.
So you have retained your rights as patentee
My lord, I have granted license paid
and given only a lesser right.
My
License.
And my lord, yesterday your
Section?
lordship
Section?
was section 69. Your lordship was asking. My lord, one more thing. The Honorable Delhi High Court order I am referring.
Yes.
Page number 31.
Yes.
My lord, in this final order passed by Delhi High Court, one of my licensee filed a suit, Amit Engineering Company, against me for granting license assignment in favor of my wife, wherein Honorable Delhi High Court dismissed the suit as withdrawn as per the terms of settlement, that the said settlement shall also be binding on defendant number 1, who is me, and defendant number 2, who is my wife.
But you don't have the terms of the settlement.
My lord, I have annexed the terms of the settlement here at the page number 34.
30?
34 months. All rights are retained with me. I have not deviated any of my rights.
Have you annexed the license agreement also?
My lord, the e-register of patent, my lord, which my learned friend was referring to, my lord, that was having the recordal at page number 11 of my written notes. I have also annexed it. Page number 11. My lord, in this entry number 2, registration under 69.
All of these are your patents?
My lords. My lord, under section 50 of the Patent Act, if I grant license or if I grant assignment to any other person, both the person will enjoy the same rights, my lord.
Under section?
50.
No, that is the right of a co-owner.
Of the patent.
You are not
So
a co-owner. Licensee cannot be a co-owner with you.
My lord, my learned friend is of
owner if his patent is granted to both of you.
My lords. And my lord, licensee is defined at page section 69.
Yes, let us come to that.
Registration of assignment and transmission, etc., where any person becomes entitled by assignment, transmission, or operation of law to a patent or to the share, my lord. In a patent, becomes entitled as mortgage licensee or otherwise to any other interest in a patent, he shall apply in writing in a prescribed manner to the controller for registration of his title, as the case may be, of notice of his interest in the register. My lord, that's what I have done, my lord, with regards to my wife.
What did you say is the license agreement?
My lord, page number 11 of the e-register of patent of my written notes, my lord.
It's not an agreement.
It's not an agreement.
There was no separate agreement.
Yes, well, I have.
You have annexed.
And your lordship kindly come to page 3 of. I handed over, my lord, the
additional written note.
Not additional, but document I have handed over. Yes, page 3. Yes, that one. Yes, that one. Page 3. Your lordship kindly peruse C.
Deed of assignment, yes.
The assignee is desirous. My lord, have got it. Page 3. Page 3. C. What has been assigned? 100%.
Yes, please come to that. Page 3 of the assignor does hereby irrevocably assign and relinquish to assignee their entire rights.
My lords, with regard to this, my lord, may I take your lordship to page number 25 of my written notes. My lord, this assignment was challenged before Delhi High Court.
Then what happened?
My lord, page number 25 of my written notes, wherein it was dismissed as withdrawn that both the patentee, means assignee, and the patentee.
Who challenged this?
My lord, one of the licensee who is marked in the e-register of
There is
patent.
only one licensee.
One licensee, Amit Engineering Company.
Not licensee. The assignee is Lipika Das.
Lipika Das, my lords.
She is the only assignee.
She is the only assignee.
You have not even defined her as an assignee. You irrevocably assign everything and relinquish your rights.
My lords, I have not, means Delhi High Court has not accepted that proposition, my lord. My lord, may I take your lordship to page number 25?
25 years.
Of my written notes. Counsel for defendant appear on 22nd February 2022 and sought time to file reply.
Who is Amit Engineering? Amit Engineering
lord,
is not a
Amit
party to this assignment.
Is the one of the licensee, my lord, who has challenged, who was your
No, they are not speaking about license at all. You have assigned all your rights to Lipika.
My lords, and this agreement was, my lord, not accepted by Delhi High Court. Delhi High Court has said that you both have the right, my lord. That's what I'm making submission, my lords.
Show me that.
My
25.
My lord, one of the licensee who was aggrieved by this assignment, my lord, has filed a suit again for declaring this agreement as nullity.
Oh, license was previous.
Previous, my lord, by me.
Therefore, they were aggrieved with this.
My lords. So, my lord, they have filed a suit before the Delhi High Court for declaring this as a nullity, this agreement. In which, my lord, I am referring page number 25 of my written notes. Counsel for defendant appear on 22nd February 2022 and sought time to file reply. And this court had granted 3 weeks time for the same and posted the matter for 7th April 2022. On 7th April, none appear on behalf of defendant. A proxy counsel appear on behalf of defendant number 1 on 5th May 2022, and an order was passed directing defendant number 1 to ensure that written statement is placed on record before the next date of hearing.
A PFG case has been made out by the plaintiff.
My lords, my lord, thereafter, my lord, thereafter, my lord, page number 29. My lord, defendant number 1 appearing in person states that without prejudice to his rights and contention, he is willing to repay the amount of 1 crore 10 lakh.
So you concede to that proposition.
My lord, thereafter, my lord, in the final.
Take me to the last thereafter, Mr. Sinha.
My lords. My lord, counsel for the plaintiff to take instructions, my lord. And
take me to the last thereafter, the last order where do you write it was decided that this is not an assignment.
My lord, at page number 31 is the last order, my lords. Wide order dated 31st May 2022, after hearing the counsels for the parties were directed to file terms of settlement. The terms of settlement have been filed on behalf of defendant number 1. As per terms of settlement, it is stated that defendant number 1 is me, my lord, shall strictly abide by the terms and conditions of the impugned license agreement dated 17 December 2020 and 11 January 2021, filed along with the suit. The said settlement shall also be binding, my lord. The language used, kindly notice, my lord. The said settlement shall also be binding on defendant number 2, who is the wife of defendant number 1. So, my lord,
this is the settlement between you. There is no adjudication at all by a court of law.
My lord,
you settle between yourselves to waive some of your rights.
My lord,
but the assignment, there is no adjudication on merits that it is not an assignment.
My lord, with regard to this, my lord, I am still the grantee.
You and your wife agreed together to yes concede to this. It was a settlement. There is no adjudication against this. This remains.
My lord, this remains. I am not on that, my lord. I am just making humble submission that this agreement was challenged before the Delhi High Court, and Delhi High Court passed this order. And my lord, secondly, my lord, I have not challenged, means I have not prayed with regard to anything with regard to
your
the
basic cause of action for the writ petition. This is not a public interest litigation. Your basic cause of action for this writ petition goes. You don't have a cause of action. Nothing is disclosed.
My humble submission with regard to this.
You are not affected at all. If you have assigned your entire rights as per this, Your wife is affected.
My lord,
The assignee.
my lord,
You are not affected at all.
my
You
lord,
don't have a locus.
my lord, with regard to this, my lord, I have humble submission at page number 9.
Of
Page
what?
number 9 of my written notes.
How can that improve you?
My lord, this is the e-register, electronic register of patent, which was filed by my learned friend right now, wherein my name as a grantee is still there, my lord. I am the grantee, my lord. Still, my cause of action exists, my lord. I can grant license, I can grant assignment. That is not a piece of cake of the central government, my lord. But I am the grantee still, my lord.
You may be grantee on paper, but if you have assigned your entire rights, you are not affected at all by the
My
outcome
lord,
of the writ petition.
Suppose, my lord, I file a public interest litigation, my lord. The thing is that I have an interest. By this way or that way, I will get the profit. Because, my lord, the thing is that my wife is the assignee. If I file the that will not be a bona fide litigation, because my wife is the assignee. And I have been also directed by the Delhi High Court to abide by the license agreements, which I have signed earlier. So, my lord, this way or that way, me and my wife.
No, Mr. Sinha, that is an agreement between you, your wife, you, the assignee, and the licensee.
My lords.
But that is not an adjudication.
My
That till this assignment deed is there. If your wife relinquish this assignment, then I could have understood. Otherwise, your wife has a right of the assignee has a right of challenge.
Clause
Not
4,
you.
My lord.
Clause 4, just once, my lord, see. Clause 4, page 4. Both parties agrees that.
The rest follows.
That is an admitted one. That is
Sole and exclusive owner, holder. No, Mr. Unnecessary waste of time.
My lord, my lord.
Wife could have filed. She is the affected party.
My lord, she will relinquish her right. That will not be an issue, my lord. She will relinquish her right if the court so desires. Because, my lord.
Not after the hearing is over.
My lord, my humble submission, my lord, I am still the grantee. My lord, one point, my lord. In this petition, my lord, if I go for a public interest litigation, my lord, I will have the interest, my lord. Indirect interest is also involved, my lord. That I cannot. That's why I have filed a writ. And my lord, in the paragraph 1 of my writ petition, I am
not advising you to file because you have one advice you have used by filing this writ petition. That you are nothing will preclude you from. So I am not putting in preclusion, non-preclusion clause now.
No, my lord.
So don't file a public interest litigation as well. But as far as the writ petition is concerned, you don't have locus standi. You have assigned your entire rights. What remains?
My lord.
How are you affected by the outcome of the writ petition?
My lord, after this Delhi High Court order, my lord. My lord.
Delhi High Court does not affect your rights in it.
My lord, after this Delhi High Court order, what I remember, there is also one agreement. There is also one agreement between me and my wife. My lord, then I will produce that agreement also, my
not
lord.
now.
Because, my lord, after this Delhi High Court agreement, because many agreements are there. I have granted almost hundreds of licenses, my lord, in this patent. And my lord, before assignment to my wife. Thereafter, I have assigned the rights to my wife. And after assignment, my lord, this Delhi High Court suit has come up, wherein this settlement has arrived.
You have settled with one of the licenses. The other licenses may come up tomorrow.
My lord,
you'll have to settle with all of them.
My lord, there is an agreement, my lord, with that regard, my lord. That has to be produced, my lord.
Not
my lord,
now.
because my lord, the assignment.
Mr. Bhattacharya took the point at the inception. Mr. Kankani also took the point on the last day. You have not produced the document till today. So now I am closing hearing. Today it is only fixed for filing of written notes. I cannot permit you to file new documents now, Mr.
My lord, most humbly, my lord. Right now, what the situation stands is that my wife is the 50% owner of the patent, and I am the 50% owner of
How
the
come this assignment did
my lord
refutes it?
My lord, after this agreement, one more agreement is there, my lord. My lord, what I am, my lord, I seek to produce, my lord. That agreement, my lord, is required for proper adjudication, my lords.
What does that say?
My lord, that agreement says that after this agreement, in addition, in addendum to this agreement, the rights vested 100% right is deviated to 50% to me and 50% to my wife. My lord, that agreement is also there, my lord.
Give out, Mr. Bhattacharya, let us consider if there is an agreement in reality. I mean, on this flimsy count.
Phrase application, phrase consideration, phrase order in the website. That is neither here nor there. But now,
no, you are relying because website still contains his name as grantee.
No, patentee, your lordship, see, grantee, initial grantee, unless
yes.
Patentee, your lordship kindly see.
Right.
Next.
Page 9.
Lipika Das Sinha, patentee. Who is the patentee now?
Yes.
This is the latest.
This is the latest. No, this is 2012.
No,
No, 20. Acha, yes, right.
It still stands in early.
As on date, what?
As on date, you're not. No.
My lord, one agreement is there, my lord.
Maybe agreement, but your name is recorded as
lord,
grantee and she is patentee.
My lord, section 50 agreement is there, my lord, because we have deviated our rights from 50%, my lord. Kindly, my lord, consider, my lord.
50.
My lord.
Produce the document by way of a supplementary affidavit. Give a copy to them. Learned counsel file the written notes of arguments which are kept on record. Full stop. In the written notes of the respondents, comma, a document is annexed, a deed of assignment is annexed to indicate that the petitioner has already assigned 100% of his patent rights in favor of his wife. Full stop. Next para. Learned counsel for the respondents also rely on the appropriate recordings in the official records indicating that the petitioner has been mentioned as a grantee of the patent, whereas the assignee stroke wife of the petitioner has been recorded as patentee. Full stop. Learned counsel for the petitioner, petitioner appearing in person submits that subsequent to the deed of assignment, comma, another agreement has been entered into between the assignee and the petitioner, whereby 50-50 rights have been shared between them. Full stop. Learned counsel for the respondents contends that even if such an agreement has been entered into, comma, the records still reflect the petitioner to be merely a grantee, whereas the name of the assignee is still recorded to be the patentee. Full stop. Hence, comma, the argument as to locus standi still remains valid. Full stop. Be that as it may, comma, in order to do complete justice between the parties, comma, the petitioner is permitted to produce the subsequent deed alleged to have been executed between the petitioner and the assignee by way of a supplementary affidavit. Full stop. Such supplementary affidavit shall be filed on April 30, 2024, when the matter shall be placed under the same heading, under the heading upgraded matters. So an advance copy of the same shall be given to the respondents. Mr. Bhattacharya and Mr. Kankani, I'll only consider the effect of that in the context of the present recording in the, because that agreement may be there, let everything come on record so that subsequently that cannot be a ground of review for you.
That review ground, my lord.
I won't give any further leave to Mr. Sinha.
My lord, I am grateful, my lord, for the opportunity, because, my lord,
Thankful to them for not opposing seriously, Mr. Sinha. I am being very candid to you. They could have very well opposed this.
My lord, in this court, at least justice will not be denied.
Now there is a fair chance of you ruining the case.
My lord, winning or losing the case, that will not be issued.
On virus, it's very difficult to let you win. Yes, next matter. Call on
Number 50.
Yes, what is the matter, please?
Because I'm appearing for the petitioner.
What about service? Good service on all. Service of upgradation?
My lord, yes, my lord. I have served.
It is there in this.
Second,
You have checked up.
I have checked.
Sufficient,
I
yes.
served it by mail. They have even requested for the copy of the petition by mail in answer to my mail, my lord. I have again.
Very good. Yes, what is the matter? Please start.
My lord, this is petition challenging the notice wherein I've been debarred. The petition number 1 and petition number 2. Petition number 1 is a firm and petition number 2 is a company. Petition number 1, firm name is MNS Co. and petition number 2, company name is MNS Co. Private Limited. My lord, the business has been taken over by
the company is one of the partners of the petitioner number 1.
The company has taken the partners have become the directors in the company.
The other way around.
Yes,
yes.
They have incorporated and they entered in a settlement agreement wherein the company was incorporated specifically for the purpose of taking over of the firm. My lords, I was registered with the various authorities where my work experience as a firm was counted, and I have filed. The bid was issued by the respondent authority, IIT Kharagpur, for the purpose of repairing and resurfacing of bituminous roads and revamping of campus stormwater drainage at IIT Kharagpur. My lord, the bid was issued on 4th of July 2023. I filed my bid on 23rd of July 2023. My lord, I was issued letter of award. Letter of award was issued on 13th of December 2023 in the name of the firm. the firm applied for the tendering process.
Hmm.
My lords, as soon as the letter of award was issued, I informed the respondent authority that since the takeover has happened and the company and the firm is being taken over by the company M&S Paving Private Limited, so allow me, and my bank accounts have also been transferred to the company. Allow me to submit the bank guarantee in the name of the company.
I'm sorry, what is your name, please, Mr.?
Pankaj Mehta.
Mr. Mehta, the taking over took place prior to the participation in the bid.
Taking over, yes.
Then how could you?
No, I am coming to that. Milord, the settlement agreement arrived between the private limited company and the partnership firm was in March 2022. It was in April 2022.
April 20, right.
April 21st April 2022. I entered a settlement agreement, but the terms and conditions, the process of the settlement of the taking over was taking time because I have to apply for the registration with our relevant authorities where my work experience has to be transferred from the firm name to the company name. Milord, that the only difficulty, I could not apply, I could not file the tender document, bid document in the name of the company because my transfer had not happened. It happened only on 1st August 2023. And with the Jharkhand Road Authority, registration order had come on 1st August 2023.
And the bid was submitted on, please give
23rd of July 2023. Bid was submitted on 23rd of July. It is on page 95.
Transfer went through finally on 1st of August.
Yes.
The transfer was completed on 1st of
No,
August.
Lord, because the transfer, I got registered. Now the bank account had given me the NOC. Now the bank were transferring my accounts also. So I sent a letter. It is still ongoing. The firm is my registration with the authority as a firm, my registration with the relevant authorities where my experience was valid. I informed my banks also. I informed all the relevant authorities that the transition is happening and requested to please transfer my experience from the firm name to the company name in terms of the settlement agreement. Because this, and I filed my necessary document with the Ministry of Corporate Affairs also. My lord, since it happened only after the submission of my bid and I got the letter from
So the takeover was completed on 1st of August.
1st of August when my company MS Paving Private Limited was registered with the experience with the Jharkhand Road Transport Authority. 1st August, Road Construction Department, Government of Jharkhand acknowledged and approved the takeover of the petition number 1 by petition number 2. It is on page 96, annexure P13.
Right. Please continue. Yes.
Millards, thereafter, I informed when a letter of award was issued to me on 13th of December 2023.
As a firm.
As a firm. Because I could not apply as a company because there were no relevant experience. And the tender document clause 1.3.1 stipulates that I should be registered with the CPWD or the public sector undertaking or with the relevant authorities having relevant experience. So the company.
But did you disclose all these things at the time of putting in your bid? I should have disclosed all these things, that it is in process, that takeover is in process.
Because experience certificate and everything was in the name of the firm only.
Should have made that clear before the authorities. And anyway, let us complete this story first, then we'll go back.
Milord.
Yes.
Thereafter, after the issue of letter of award, they asked me to submit a performance guarantee. I sent a letter on 18th of December, on 13th of December. The letter of award was given on 5th of December. I sent a letter on 13th of December 2023, that there is a change in the constitution of the firm and it has been taken over by the company and the process is complete. And then there was no response. I again sent a letter that please allow me to submit the bank guarantee in the name of the company. Because the constitution has changed of the firm to the company and the partners of the firm have become the directors of the company. There was no response. That petition number 2 was sending this letter. Thereafter, there was a letter by the respondent authority to the petition number 1 that you please submit the bank guarantee in the name of the firm only. Again, I responded back on 19 December 23 itself that because the banks have already transferred my assets from the firm to the company, it is not possible for the firm to give the bank guarantee. Allow me to submit the bank guarantee, acknowledge the change in the constitution of the firm to the company, and allow me to submit the bank guarantee in the name of the company, M&S Paving Private Limited. My lord, there was no response to that. However, then I received a show cause notice, which was given to the petitioner number 2. So far, respondent authority was not acknowledging petitioner number 2 as that they have filed anything. They issued a show cause notice to the petitioner number 2 that why you should not be debarred. Because you have violated, you did not disclose, and you try to fraudulently get the award of the contract. My lord, the petition, then I responded to the show cause notice immediately on 2nd of January. 2nd January, no show cause notice was given, and 12th of January, show cause notice reply was issued. It was issued by respondent number 2
on 12th of January.
on 12th of January. Milord, on 12th of January, petitioner number 2 responded that I I did not file the bid document because I did not have the requisite experience. I did not try to play fraud upon them. It is only because of the change in the constitution of the firm and the company was taking place. Petition number 1 to petition number 2. That is why we submitted the bid in the name of petition number 1, the firm.
The transfer is parallel insofar as the partners and the directors are concerned. I mean to say that the exact partners who are the partners, they have become the no other directors.
No other director.
And all the partners have become directors.
Only 2 partners, 2 become partners have become.
So it's an exact parallel transfer.
Milord, exact parallel. Milord, thereafter on, they did not recognize me.
Yes.
Thereafter, on 27th of February, they issued me the termination notice to the petition number 1, whom the show cause notice was not issued.
What is the date?
27th February 2024. Page number 32, annexure P1. Milord, show cause notice was issued to petition number 2.
Understand. Termination to 1.
Yes, and termination to petition number 1, wherein they mentioned that petition number 2, we are debarring petition number 1 and 2. There was no time period. How long? For indefinite period, they debarred me. On 14th March 2024, on
it's a termination as well as a composite debarment also.
Milord, termination, withdrawal of the letter of award, termination of letter of award, and debarment for a no time period. It just mentioned that you've been debarred from participating in any tendering process. Thereafter, on 14th March 2024, when I checked on e-procurement portal system, I found that petition number 1 and petition number 2, firm and the company, both PAN cards have been debarred for a period of 2 years till 2026, which is at annexure page number 33. Because I am challenging both the impugned termination notice and the debarment notice, and as well as the debarment on the e-procurement system.
Have they cited any clause in the either in the debarment order? Let me see the debarment order first.
Milord, this is on
page 33.
Page 42. 32.
32 you said, yes. So 32 was the yes, right.
Milord, the show cause notice also I should have.
No, let us see the order. Have they relied on any particular clause of the tender document?
No, Milord.
I think so. What is the worst clause against you, Mr. Mehta?
Milord,
Tell me that. Let us start from
I mentioned in the reply.
Because they are not here, you have to argue for them also.
Milord,
yes.
I mentioned specifically that when the show cause notice was issued to me, to the petition number 2, I responded back that there is no particular clause in the GCC. I have to submit the bank guarantee, and please explain me that how do I do it? Because my bank accounts are transferred. Milord, I may take it to the relevant paragraph in the show cause notice reply, which is at page 140. I have responded to specifically to this. Milord, first,
you argue for them. What could could be their base clause?
Milord, page 139 is the show cause notice.
Yes.
And I have specifically asked, Milord, page 138.
138 is the show cause notice.
Page 138, which in annexure P20. I specifically mentioned that there is no provision. Milord has it, page 138.
I have page 138, yes.
We got your email dated 19/12/2023, in which you have specified that without submission of performance guarantee, your contention of quoting the clause of GCC is not clear. In this respect, we need to clarify that as per the previous correspondence dated 13/12/2023, 18/12 and 19/12/2023, we already cleared that due to the change in the constitution, our bank will not be able to issue performance guarantee in the name of MNS Co, the partnership firm. In respect of change in the constitution, there has not been any clause mentioned in GCC except para mentioned in annexure 1, performance guarantee. In this situation, we request you to suggest us how we will submit performance bank guarantee if our firm MNS Co has been taken over by the private limited company MNS Paving Private Limited, and all transaction, business operation, assets and liabilities controlled and managed by MNS Paving Private Limited. We have to follow the GCC, and at the time of agreement, your office will ask for agreement with that person in whose name performance guarantee will be submitted. Before your office in this situation, MNS Co has already been taken over by MNS Paving Private Limited. Then what would be the legal validity of the agreement? But there is no clause mentioned in respect in GCC. Therefore, we are requesting to amend the constitution as well as name of the contractor from MNS Co to MNS Paving Private Limited and extend the period of 15 days to submit the performance guarantee without any interest and penalty till the period of amendment made in your records. Thereafter, the show cause notice was given on second, which is on next page.
According to you, the asset transfer took place after the participation in the tender.
Because I
What
was
document have you annexed in that?
I have annexed with regard to yes. 1st August 2023, there is an order from the Jharkhand Authority, which is
Yes.
at page number. It is on page 96, annexure P13. No, not 130, page 30, 96. Page number 130, my lords. Annexure P13. Page 130. So this is a letter issued by the Jharkhand Road Transport Department, wherein
130?
Page 130, annexure P13.
Yes.
Milan, may I read it, Mayor?
Please.
1st August 2023, this has been issued by the Path Nirman Vibhag,
Yes,
Road
yes,
Transport
yes.
Department. MNS co-partner Shri Manoj Kumar Dev and Shri Sunil Kumar Yadav. Address MS Tower, Khotanband, Dumka का निबंधन संवेदक निबंधन कोड सो एंड सो ने विभागीय द्वारा 8 जनवरी 2000 तक की अवधि के लिए किया गया है। उक्त फॉर्म को एमएनएस पेविंग प्राइवेट लिमिटेड वर्तमान पता सो एंड सो जिसके वर्तमान निदेशक श्री मनोज कुमार देव एवं श्री सुनील कुमार यादव सेम पार्टनर्स हैव बिकम द डायरेक्टर द्वारा सभी ऑनगोइंग प्रोजेक्ट्स एसेट्स एंड लायबिलिटीज के साथ विधिवत टेक ओवर कर लिया गया है। भारत सरकार कॉर्पोरेट कार्य मंत्रालय द्वारा दिनांक 17 अगस्त 2020 को निर्गत सर्टिफिकेट ऑफ इनकॉर्पोरेशन प्रमाण पत्र में इनका कॉर्पोरेट आइडेंटिटी नंबर सो एंड सो पैन नंबर सो एंड सो तथा टैन नंबर सो एंड सो अंकित है। उपयुक्त टेक ओवर के आलोक में एमएनएस को द्वारा पूर्व में पूर्ण किए गए कार्य एवं वर्तमान में आवंटित कार्य से संबंधित दस्तावेज अभिलेख एवं कार्यों से संबंधित आवश्यक धनराशियों आदि एमएनएस पेविंग प्राइवेट लिमिटेड के नाम से परिवर्तित किए जाने समझे जाने हेतु संबंधित पदाधिकार विभागानुसार नियमानुसार कार्यवाही सुनिश्चित करेंगे। Milord, this letter was issued on 1st August.
This was a direction.
Order.
संबंधित पदाधिकारी विभाग नियमानुसार कार्रवाई सुनिश्चित करेंगे. So after that, what happened? Next page.
Next page, Milord.
Yes.
Certificate has been given, Milord. On 3rd August 2023, which this has been issued by the same department by the Path Nirman Vibhag, Jharkhand Ranchi.
What is the English of Nibandhan? Constitution. On incorporation, what? I'm not sure. Nibandhan. Either incorporation or constitution, something like that must be.
Nibandhan.
Because I have to put my order in English.
I check.
Anyway, but on termination, incorporation should be incorporation.
Nibandhan Praman Patra, incorporation.
Nibandhan has to be incorporation. Incorporation.
Registration certificate.
Apparently.
It is a registration certificate.
Registration.
Registration certificate.
Nibandhan is registration already.
It is registration certificate because I mentioned in the annexure that this is a registration certificate given on 3rd of August.
You will not get any order of stay on the termination, but regarding the you have been given a show cause for the banning also.
You know, the show cause was for
Composite show cause, debarment. So, let me see the show cause again.
Show cause was given to the petition number 2 only, not to petition number 1.
Yes, but petitioner number, you are now petitioner number 2.
Milord.
So it's a valid show cause notice.
Show cause
is at page?
Page 139.
139. Where is your reply to that?
Page 140. I have given a detailed reply, para-wise reply. Each point has been replied, my lord, in detail. They have not considered this.
And then the final order is at page 33.
Page 32. 32 and 33. My lord, because of this debarment, I am not being able to participate in any tendering process, my lord. That is the only difficulty. They have debarred me in the e-procurement portal system also, my lords. That is the only difficulty, my lords.
After order record, the petitioner number 1, The partnership firm is no longer there.
It is still
It is still there, but it has been taken over by the assets have been taken over by the
assets, liability, everything has been taken over.
right.
It is still executing.
The petitioner number 1 is a partnership firm having 2 partners. First up, the said partnership firm participated in the subject tender at a juncture when a takeover process was ongoing, whereby the petitioner number 2 company was in the process of taking over the assets and liabilities of the petitioner number 1 firm. First up, the petitioner number 1 came out successful in the tender process and was awarded a letter of award. First up, next para, such LOA was issued on December 5, 2023. First up, on December 13, 2023, when required to give a performance guarantee, it was indicated by petitioner number 2 company that the takeover process has since been concluded. First up, however, a show cause notice was issued to the petitioner for as to why the letter of award should not be terminated and the petitioner should not be debarred from participating in tenders floated by the respondent authorities. First up, it is argued by learned counsel for the petitioner that the petitioner gave a comprehensive reply which has been annexed to the present writ petition, point by point, explaining that the takeover process and the transfer of assets and liabilities was recognized formally by the Jharkhand government only on August 1, 2023, whereupon a certificate of registration was issued. First up, as such, on the date of participation, the petitioner number 2 company could not have been one of the bidders. First up, next para, as of today, it is argued that the entire assets and liabilities of the petitioner number 1 have been taken over by the petitioner number 2, and as such, all further transactions, including furnishing the performance guarantee, has to be done by the petitioner number 2 and not the petitioner number 1. Push up next para. It has also been argued that there was a parallel takeover, in the sense that the 2 partners who were the only partners of the petitioner number 1 firm, have become directors of the petitioner number 2 company. First up, as such, it cannot be said that there has been a substantial change in the ownership insofar as the assets and liabilities are concerned. First up, next para. Although the petitioner number 2 company is a separate juristic entity, in view of the peculiar facts of the case, it cannot be entirely ruled out that the petitioner number 2, having taken over the assets and liabilities of the petitioner number 1, virtually remains for all practical purposes the same entity which participated in the tender process at the inception. Pushed up as such, merely on the ground that there was a change in the constitution of the firm by takeover by the petitioner number 2 company, particularly in the absence of any specific clause in the tender document debarring such change, a question arises as to whether the respondent authorities were justified in debarring the petitioner and terminating the contract. Pushed up, next para. As such, since a strong prima facie case for hearing the writ petition on merits on the above questions have been made out, the respondents are directed to file their affidavits in opposition within 3 weeks from date. Full stop reply, if any, shall be filed within a week thereafter. The matter shall be listed on June in the monthly comment list of cases for June 2024. Full stop. There shall be stay of operation of the impugned order dated February 27, 2024, insofar as the debarment of the petitioners from participating in future contracts, future tenders floated by the respondent authorities is concerned, till June 30, 2024 or until further order, whichever is earlier. However, it is made clear that the termination of the letter of award to the petitioners is not being stayed for the present, and the petitioner number 2 company Any action taken in the meantime by the respondents shall abide by the outcome of the writ petition in that regard.
Milords, may I please mention 27th February 2024 and 14th March 2024 as well, Milord.
Very well. Very well. That is a culmination of continuation.
That is in continuation. 27th February, the termination notice was issued, and 14th March, e-procurement portal system they uploaded on both the PAN cards of the petitioners. Page number 34. 30, right? 34. Serial number 16 and 20. PAN
But
card
it has been already uploaded. Then they have to take down. There has to be a mandatory direction then.
Milord, they uploaded on e-procurement system, public procurement system. PAN cards of petition number 1 and petition number 2 both.
No, Mr. Mehta. Whatever that means, I mean, debarment order will remain state, but this will remain for the time being.
Because
I cannot pass a positive direction.
Because I will not be able to participate in any tendering process.
So this stay order won't mean anything then. Let us see under what category you have been put. Your tender status, yes. Now this is the debarment list, all right, yes. You are, what is the name of the?
MNS 16 and 20.
16 and 20.
MNS Paving Private Limited and MNS Co. PAN cards have been mentioned, Lords. And this is debarment list.
The respondent authorities are further directed to take down the names of the petitioner numbers 1 and 2 from the debarment list in the central public procurement portal, comma, subject to the outcome of the present writ petition, comma, also till June 30, 2024 or until further order, whichever is earlier. প্রথম সেন্টেন্স একটা দিয়ে দেবেন। Despite service of a copy of the service of copies of the writ petition as well as service of notice of upgradation, comma, none appears for the respondents at the time of call. Affidavit of service filed to be kept on record. This will be the first paragraph. Thank you.
Great. Lord, since I come from Delhi, if time may be fixed for 30th of June.
Matter is fixed for monthly list of
I have to remain here and face the other matters. So sorry, Mr. Mehta.
Great.
Thank you. Yes.
Item number 51.
Yes. Petitioner.
No. I am the respondent, my lord. I have a preliminary point of maintainability of this writ.
Why not maintain?
May I?
Lord, today is fixed for giving our affidavit in reply.
Yes.
So, my lord, yesterday we affirmed it and sub copy upon my learned friend, and we are filing this.
Opposition you have already filed.
Lord, she was pleased to, my lord, modify my lord, the interim order, my lord. Why I tell your lordship, my lord.
In fact, my lord, modification was done, my lord, on the last occasion because they have taken their 1 week and our 1 week time to file the opposition, a bulky opposition during the Saturday, Sunday, my lord, we could not meet the client and could not prepare the reply. So we prayed for a time on the last occasion and through my.
No, you're filing it. I'll record it. Yes. So what is the matter? Let us hear.
This is with regard to, my lord, an election of a housing society, my lord. My lord, coming, my lord,
He is pointing out upon the maintainability.
Maintainability, my lord.
Maintainability because of the election dispute, because it's an election dispute.
Yes. Why I say so, my lord. I will take your lordship to act on the bylaws, my lord. To that, my lord, may I, my lord, emphasize, my lord, the genesis of all elections, my lord, is where, my lord, brought down from the Constitution followed by the Representation of People's Act, my lord. So Article 329, my lord, on other articles, my lord, also mentions that election cannot be challenged in a judicial review, my lord. And there are series of judgments, and I'm not going into that, my lord. Today, as we stand, my lord, if we look at the bylaws of the apartment ownership bylaws, bylaw 8 prescribes that a special general meeting has to be held. I will take your lordship to the bylaws once, my lord. And the person designated will hold a special general meeting and will conduct the election. Now, who is designated? The person who the competent authority says that you are designated, now you go ahead and hold the election. He is not an officer of the competent authority. He is a member of the society itself. So he's a private individual. So, Malad, my understanding of the statute is, Malad, my respectful submission is, once, Malad, the competent authority delegates its power, or rather, it's not a technically a delegation, gives instructions or kind of, Malad, delineates it to X, who is an individual, a private individual, saying that you have the copy of the registration now, your society is registered, your housing society is registered. Now you hold an election under Rule 8, the competent authority becomes functus officio. The role of competent authority is over. The curtain falls there. And in the Act and the bylaws, nowhere it has been specifically stated whether the competent authority exercises jurisdiction over the electoral matters of any housing society. The law is completely silent. Now, if drawing analogy here, if the law is completely silent on this aspect, I have to fall back on the constitution and the genesis of the election and how the election petitions are dealt with.
The challenge to an election, where should they go?
If there is a challenge to an election, they have to file a suit in my respectful sub. Because if there is a challenge to an election, there will be disputed questions of facts. Where in the affidavit also,
the premise of non-maintainability of a writ petition is, Mr. Ghoshal, that there is a provision for an election petition being filed.
Yes, absolutely. Now, if there is no provision, if there is no provision,
how can a writ be barred?
Writ be barred on the simplicity of ground that if the act itself is silent.
That is the reason that it is made.
May I elaborate on this, Malad? If the act is itself silent, Malad, and there are disputed questions of fact. Now, in an election petition, if somebody canvasses in a 226, Malad, my little understanding, Malad, I say that X, Y, Z has not been done in the manner it should have been done. That is my allegation. The other side comes up and says, no, X, Y, Z was done, but A, B, C was not done. So these are all disputed questions of fact that has to be gone into trial.
These are two different objections.
Absolutely, Malad. These are my twofold points, Malad, which I would like to argue, Malad. May I, Lordship, take your Lordship to the Act once, Malad, the bylaws once of the...
Whatever you have said, I take on face value. I
Fair
accept
enough,
that.
Today, Malad, as it's...
On the basis of your arguments, my question is, if there is no forum provided in the statute, then why should Article 329 apply at all? One. Secondly, Mr. Ghoshal, there is a story behind Article 329.
Yes,
now, 226 is a judicial review which we exercise.
Yes.
226 and 329 both are constitutional provisions, right? So, Constitution delineates the executive and the, as we all know, the three separation of powers and all. So, Constitution has its implicit safeguards so that the courts do not trample the rights of the executive. Election Commission of India is there for the central elections and state election commissions. Now, for that reason, when Election Commission is in season, it's a constitutional authority having powers. It has to be impeached, almost akin to High Court judges. So, it's a parallel forum which has been provided for these remedies. That is the reason why another constitutional authority, to avoid conflict, the High Courts, they have been debarred from looking into this under Article 329. So there's a conflict between equal powers, co-equal powers, both of which flow from the Constitution. 226 on the one hand, 329 on the other hand. Both are constitutional powers. They operate on a parallel.
Absolutely.
The moment we come down to a statutory election, Mr. Ghoshal, it's a statute which takes power, derives power from the Constitution, but is in a sense not a subordinate legislation, but derived authority. It's on a subordinate footing than a constitutional power. And that is the premise of L. Chandrakumar and all for protecting judicial review. And it's a basic structure also now. So therefore, the moment we come down, it's not a constitutional power authority versus another constitutional power being used by authority. Then it's a judicial review, a constitutional power under which operates the statutes. So if a High Court under 226 can look into statutory violations, then why not even elections? Because it's not on a parallel footing as 329 in the general elections. So therefore, if the statute provides some particular remedy, it's a different argument altogether, alternative remedy argument, which is entirely different from 329 argument. So elections is not a magic word, Mr. Ghoshal, in my opinion, subject to correction by you. Election is not a magic opinion, not a magic word. Either it flows from 329, when 226 powers are prohibited, as I made it clear. I don't want to repeat. So that is my take on this. So refute that and get your order.
Yes, my lord. Now, my lord, coming back here, my lord. Today, my lord, I understand, my lord, there are, like, say, for example, if we take the analogy of the West Bengal Municipal Election Acts, or for the example of West Bengal Panchayat Elections Act, my lord, it is a complete code by itself, deriving, my lord, the essence of RP Act, the essence, how it has to be governed, and if there is a
But as per
dispute.
your submission, Mr.
Yes,
Ghoshal, this act does not provide any such remedy.
No remedy is there. And if there is no remedy and there are disputed questions of fact, my lord,
Again, you are putting in a third argument here. 329 is one argument.
That is one argument, yes.
Alternative remedy is another argument. And disputed questions of fact is a third argument. Which is a defense to writ petition. If it's disputed questions of fact, Mr. Ghoshal, you are right. We'll consider whether it's a disputed question of fact. If it's a disputed question of fact, there are judgments also galore which say that court cannot shirk its duty merely on the pretext that it's a disputed question of fact. The court has to see whether detailed evidence has to be taken and assessed. If that is not necessary, even if it is a disputed question of fact, there is at least one judgment, recent judgment of the present CJI, which says that court cannot shirk its duty, has to decide disputed questions.
I'm aware of that.
Must be aware. I don't remember the citations, but you will cite that if necessary. I have that confidence. So you can take up disputed questions of fact. We have to consider. Then we have to hear her first.
Yes,
Ms. Shenmugam has to be heard.
Absolutely.
It's not a preliminary objection.
No, absolutely not. I only, my lord, I will come.
And I borrow from your argument, Mr. Ghoshal, since there is no provision, 226 is very much maintainable.
But my respectful submission, my lord, my understanding is, my lord, if there is no provision, my lord, and the act does not provide, there is one thing the act does provide is under sections bylaw 16, which a member can raise a competent authority. That is absolutely not applicable here. Now here today we are looking at an election of a private organization.
Competent authority only under 16B has power.
Yes.
Here
Now,
there is no 16B scenario.
Yes, absolutely not a 16B scenario. Now today, my lord, if there is no statutory authority exercising its intervention in a mechanism of election. I'm not using the word election.
There is no statutory remedy, therefore 226 is maintainable.
My respectful submission would be, my lord, if there are like today, my lord, whether X was done, X was not done on affidavits, my lord, perhaps, my lord, my respectful submission is perhaps not.
We hear her will consider it's a dispute.
Perhaps, my lord, not.
Hear the petitioner first.
Senior client already filed a reputation pending.
No, I've clapped that too.
No.
Thank you for give the number. Anyway, I'll hear Ms. Sengupta first.
But I'm not aware. I'm only.
She'll take that into consideration and make her. Yes, Ms. Sengupta. Yes.
My lord, my case in nutshell is that the competent authority, while issuing the certificate of registration, they made it clear that you have to appoint one citizen from amongst yourselves as presiding officer and hold the election. So, my lord, appointment of presiding officer was done as per direction of the competent authority.
Apartment ownership act. Apartment ownership. Let them do some work. Yes. Yes, Ms. Sengupta. I'm sorry. Please continue.
Yes. Now, lordship, I am showing the registration certificate given by the competent authority.
Yes. Page
26 of the writ petition.
Thank you.
My lord, first is this registration certificate, page 26.
Yes.
I hereby certify that is the town Rajarat Association of Apartment Owners. This is registered. Then the next page is the modalities which have to be undertaken by the residents of that association. Page 27. Yes. Now, my lord, I am reading from 1, 2, 3, third paragraph.
Right.
It may be stated that as per bylaw 3 of the West Bengal Apartment Ownership Act, each apartment owner is a member of the association. And when an apartment is owned by more than one person, any one of them will be the member of the association. It is further stated that within 15 days of formation of this association, you shall serve notice upon each member of this association, fixing therein the date, not before 7 days from the issue of such notice on
Ms. Sengupta, I'll request you to place those provisions which have been violated according to you.
Milo, then this portion has not been violated. Only that the appointment of presiding
Usual, the
officer
bylaws
is
have
one,
been quoted. And all.
and Milo, thereafter the presiding officer,
Yes.
they have taken arranged for an election team, as there are 29 blocks and total residents are 1386 in number. So the presiding officer in the first meeting
Yes.
asked for nomination from the residents, who wants to be the election commission member. And also he laid down the nomination for the block representatives. What is the provision is that, first the block representatives will be elected. The elected block representatives, they are the board of managers.
Right.
And the board of managers in their first sitting will elect the office bearers, that is the president, secretary, etc. And thereafter, that elected office bearers with the board of managers will be sent to the competent authority under Form 3.
That the board of managers will send that.
The president of the, my lord, the committee, the president of the office bearers, the board of managers will elect the office bearers.
Yes.
The office bearers will be presided by the president, and the president will send everything to the competent
The
authority.
board of managers decide the office bearers.
Office bearers.
Office bearers will select their own president.
No, office bearers including all. Office bearers including president, secretary.
Oh,
assistant
the office
secretary.
bearers in that sense. I'm sorry.
That sense.
Right.
And then thereafter,
The president sends that list to the competent authority.
in Form 3, that who are the board managers and who are the office bearers. So, my lord, this is not that the competent authority is not in session of the matter after the presiding officer is elected. Not that. It is a part of the total process.
Yes.
Now, my lord, the presiding officer, taking into consideration the total number of blocks and residents, they said two things. First of all, asking for nomination for the block representatives.
Yes.
Those who are 48 in numbers, where there are more residents, there are 2, and 1 in where is the small residence. Ours of Magnolia block, there only 1 representative can be elected, who will be the board of managers.
It's a proportional representation sort of thing.
More or less, 26, 1, because the maximum limit is 48. According to these bylaws, the minimum level of board of managers will be 3 and the maximum is 48.
So your grievance is at what level? The block level?
Block level. At block level, I was one of the contestants. I contested.
You contested for being a block representative of Magnolia.
Of Magnolia.
Right. What happened there?
Now, my lord, the election was over at 4 or 4:30 p.m. on 10th of March. Thereafter, what happened? The presiding officer also formulated that in the event of any resident who is obviously more than 8 years, does not come for vote, the home collection, the election team members will visit the home and take the home collection.
That is for the purpose of electing the block representatives.
Block representatives after election are the board of managers. Block representatives, they are the board of managers after election.
Right.
After election, they are the board. They will constitute the board.
Right.
They will constitute the board.
Right.
So before the election, they were called the block representatives.
Yes.
Give the nominations. So they have given the nominations. Now, my lord, the problem started with one Veena Singh, who requested the petitioner, like 2022 election, in 2022 election for the ad hoc management committee. For this is the first time election after the registration of the association. Earlier, since 2016, there were ad hoc committees who were working on 2 years tenure basis. Now, my lord, she requested also in 2022, then also the election team, they gave home visit and took her vote. But this time, when the election members went for his home collection, she said, no, I shall not cast vote. I don't want to cast vote. Matter ends there. She did not say anything else. But the respondent number 7, who is another co-contestant of this Magnolia block, these 2 persons in fact contested, the petitioner and respondent number 7. Now, respondent number 7 and some other co-contestants and some residents, they took a who they are from and said that it's the petitioner who played fraud and his candidature should be cancelled. Milord, a horrible situation. The presiding officer, a senior citizen, after 4:30 till 10, no counting could have been done.
What is the alleged fraud against you?
That I said the presiding officer to take our vote, requested the presiding officer to take our vote from home collection. In fact, she did not cast vote, so nobody is benefited.
This is only regarding Bina.
Only regarding Bina Singh. Only regarding Bina Singh.
All right.
In the opposition, they have stated that the petitioner might have been taken that her position will not be stable this year. So she asked.
So you say since she did not cast her vote, she refused?
Nobody.
So it's a non-issue.
Non-issue. Nobody has been
She actually
benefited.
refused, according to you.
Before the election team, I shall not cast my vote. He said that.
Very well.
Now, that respondent number 7, what did? She went to that Veena Singh,
Yes.
persuaded her to sign on a letter. The handwriting of letter and the signature of Veena Singh both differs. So it appears to us, to me, actually my client, that the respondent number 7, she wrote the letter, went to Veena Singh and came and gave it to presiding officer. They are said that I did not want to cast my vote. This much. But when presiding officer declined to declare that my candidature is cancelled in want of
No, Veena
evidence,
Singh, that letter, in that letter, Veena Singh said what? That
that I shall not cast my vote. Well, I have annexed that.
No, I shall not cast my vote.
I have not cast my vote. That's all.
I have not cast my
I
vote.
have not cast my vote. That is after election. I have not cast my vote.
So how does it make a difference?
Then only presiding officer said, presiding officer upon being persuaded that what is the evidence that the petitioner asked her. Then again respondent numbers went to Veena Singh, took another letter from him that I did not, the petitioner, that I shall give vote from home collection. This is also no issue. But the
In the
contract,
second letter, Veena Singh said what?
Veena Singh said, just showing the letters. Well, I'm just reading. I have annexed it.
Yes, whatever.
That is also annexed to their opposition.
So we'll kindly take page 63 once and 64 once, and I will have a reply to this.
Well, I have annexed.
Kindly
When
see
I-
page 60.
please,
No,
please
let her
allow me.
complete.
Yes,
Please
I
allow
will
me
just.
to argue in my own way. Please allow me. The respondent number 7 said that I first took one letter from her. When it is not clear therefrom that the petitioner requested her to cast her vote. So again I went to her and to another letter.
What did she say? Did she say the second time? That is also important.
Yes, my lord. Veena Singh's letter is at page 43 of my reply. Because earlier I did not get it. I got it from their opposition. They have annexed everything. 43 of my reply.
So this is not a letter
No,
by Veena Singh.
45. 45 of my reply. To the EC. 45. This is to inform you that I, Veena Singh, wife of Raman Singh, have not voted for the 10th March 24 Siddha Town election. Request you to kindly note that the above fact point.
So how does it make a difference? How does it make you a fraud?
Nothing. But then what did he do? He took an
This is the second letter.
Second letter is at page 46. My lord, how unfairly the respondent number 7 acted being a contestant of the
I
election.
really feel for Veena Singh.
Yes, my lord, how much she
Poor
was
lady, poor lady.
she was pressurized. And her husband is not here, she is alone. That is why she requested for taking from home collection. Then, my lord, the bottom portion. Respondent number 7 written in his affidavit of opposition as presiding officer did not cancel the candidature. So he again going to Veena Singh and took this letter. Please note that I, Veena Singh, owner of so and so, have not requested or authorized Mr. Sami Malum to send any email communication on my behalf to any other. My lord, this is nothing but an act of pressurization upon Veena Singh, a lady who resides alone in the
So at best, she says here that she did not authorize you to communicate on her behalf that somebody goes and collects her vote. So how does it make a difference even then?
But even thereafter, they pressurize the presiding officer so much, but a CCTV camera recording, video recording clear that
Yes.
8:30 PM, the presiding officer was compelled to declare that petitioner's candidature is cancelled. And at 10 PM, counting was started. And it completed at 1:30 PM. Such horrible
AM. Yes.
Such horrible pressure upon the presiding officer and the election team compels them to make series of representation of
Please
resignation.
show me that communication to you that your candidature has been cancelled.
No comment, no, nothing, verbal.
Then what happened? Then the election went on without you.
They may know the election was complete by 4:30. So, my lord,
Morning.
thereafter, by 4:30 of PM and seals 4:30, no ballot boxes were opened till 10 PM. And thereafter, the counting was started except Magnolia Block. Magnolia Blocks, the ballot paper box is still under sealed cover in the strong room under the facility manager.
Therefore, the board has not yet been formed.
Board has not yet been formed, but then what did one election commission member did? He claimed to be the sole member of the election team. He gave a certification to the competent authority stating that the most of the election commission members have resigned. So as sole member of the election team, I am declaring this result. After counting, the results were not declared. So I am declaring these results, and he has shown the respondent number 7 as elected. And
Sengupta will continue tomorrow. I have to hear some original said matters. I was engrossed in the fate of Bina Singh. That's why I was...
Only one thing is that my lords, in the first day's order, CCTV footage was also under custody. Would it be my lord's pleasure to ask for all those? If, my lord's order is that if required, that will be called for. So just to see that what annoyance was created in the premises and what misrepresentation was made by one of the election commission to persuade the competent authority to issue a form, accept the form, the certificate.
Please come back on 29th of April. I'll keep it at 2.
Well, since from 27th to 2nd of May, I'm not in India, my lord.
No. Not in India?
No, I'm in Germany, my lord. I will be in Germany, my lord.
So you argue from Germany, no difficulty. They have video online thing.
Absolutely, but I will be going and
India
visiting.
is better now. As per the advertisements, India is probably better than every European
country. Absolutely. But there will be a time difference, and I will be delivering lectures in 4 universities over
About what?
About left-wing socialism or right-wing activism, which is in...
No, better not to do the hearing during the elections. So when do you come back?
I'm coming back on 4th morning. It's a Sunday. So 5th, Lordship can keep it.
So, but your board will be hung till then.
There's an interim order till 30th.
What is the interim order?
The interim order is that the
ad hoc committee will continue.
Will continue. In fact, ad hoc committee has no control over the financial liability. That is controlled by the management, the builders, Siddha Town builders. Only day-to-day management is going on by the ad hoc committee.
What is the suitable date for you, Mr. Ghoshal?
Well, 5th is fine, my lord. Because I'm the whole week I will.
5th is a Sunday. So
6th.
6 May suits you, Mr. Gupta, and all of you.
Earlier, the first occasion interim order was still disposal of the writ petition. Thereafter, as
you are not there.
Within 2 days, no, I was there, but within 2 days we could not file the reply. So my lord was pleased to limit it.
Now penalty for left-wing socialists. So it will again be till disposal.
Yes.
No, I'll put it for a limited period. Otherwise, you won't have any handle for extension.
We are ready for hearing.
The interim order grant. The matter is heard in part. For further hearing on May 6, 2024 at 2 PM. Of the interim order granted earlier is extended till June 15, 2024 or until further order, whichever is earlier.
Grateful, my lord.
First item at 2 PM, my lord, if possible, my lord.
The affidavit in reply filed today, lordship.
Affidavits in opposition and reply filed today be kept on record.
Yes, yes.
Next. Hey, Prodigy said.
Deeply obliged, my lord.
Thank you. Yes. Oh, judgment.
Original side matters for judgment item number 1. RKD Niraj JV and others versus the Union of India and others.
Sorry. WPS 173 of 2024 is dismissed on contest without any orders to cost. Urgent server copies.
May I pray for the stay of the judgment?
Stay of dismissal. After the order is passed, after the order is passed, a stay is prayed for on behalf of the writ petitioner, full stop. However, comma, since the writ petition has been dismissed, comma, there is no scope of grant of any interim orders. Full stop. Accordingly, such prayer is refused. এটা দিয়ে add করে তারপর if I had allowed it, then I would have stayed there. Yes.
Contempt matters, item number 2, Messrs. HON'BLE
My
execution slip.
application, my lord.
Yes, Mr. Ghaffar.
Your Lordship, my lord, this application was taken up earlier. Directions for affidavits were passed.
Mr. Dhol, you are for? For? Finance? Yes,
Lord,
sorry,
may I
please.
file my affidavit in reply to the 3 affidavits in opposition received?
Oppositions were filed previously.
Lord, it must be lying with my learned friends.
Huh?
Not only thing, my lord, it is appearing as item number, you have preferred an appeal, item number 50 before the division.
15.
50. It was mentioned.
Never be taken up.
My lord, no, 34, it has come to, it was mentioned today. But I was not, Mr. Siddiqui had mentioned it. He has been told that it will be taken up this week. I'll leave it to my lord.
My lord, may I indicate, my lord, no notice of mentioning was given.
No notice was not.
My lord, your Lordship would also
Mr. Ghaffar, are you enjoying any interim order here?
No, my lord.
What is the nature of the dispute?
Nature of the dispute is my lord's order, my lord, directing
No,
the
this is a
respondent
contempt appeal.
authorities.
I'm taking
Contempt.
up. Oh, contempt, there is no scope of.
My lord, rule be issued, my lord, is all I'm praying. My
No,
lord.
no. Rule issuance means they have to come personally. Sir.
My lord,
I'll give them another week.
My lord, your lordship would kindly consider, my lord, the appeal is not yet for admission, my lord. It is not yet admitted. Since October, my lord, may I just indicate to your lordship, my lord, once, my lord, the appeal was filed in September, taken up in October, my lord. October, the delay was condoned. We did not stand in the way, my lord. The order would show that. Thereafter, my lord, since October till date, my lord, no steps have been taken. Even now, I understand my learned friend has
I'll now
mentioned
put in
this.
some incentive for the division bench in my order. Learned counsel for the alleged contemner submits that the appeal preferred against the parent order has been mentioned before the division bench for being taken up early. Full stop. It is anticipated by the alleged contemners that the appeal may be taken up during the course of this week. Full stop. Next para. Hence, comma, as a last chance to the alleged contemner to obtain an order from the division bench, comma, the matter is adjourned till April 30, 2024, when it will be placed under the same heading.
My lord, the affidavit in opposition and replies filed.
Yes. Affidavits in opposition and reply filed today be kept on record.
Okay.
Mr. Chakraborty, now cite this before the. And if a remand order comes, Mr. Chakraborty, I'll dismiss that remand order, I'm telling you. Sorry, review liberty is given to you. I'll definitely reject. Several matters review, liberty to review. If a review comes before, I'll definitely reject it. I'm just telling you beforehand.
One matter, my lord, I'm before and
Explain to Mr. Ghaffar outside court why I'm saying this. Yes.
My lord, obliged.
Next.
Item number 3, FCIB enforcement
On
and
behalf of the
detective agency.
petitioner, my lord, I am humbly praying for short pass by Mr. Shonok is appearing in another.
No short pass over here, you have complied
Lordship,
or preferred an appeal, whatever.
Lordship, in my most humble submission, your Lordship, there is no contempt, your Lordship. Lordship, there is no violation. If Lordship kindly sees your Lordship's order, my Lord.
You start the matter, you are competent in them. You started on one day. You start the matter. Yes, what is the.
If Lordships may kindly come to your Lordship's order, my Lord, which is there at page number 158, my Lord. And my Lord, the operative portion is there at page number 162, your Lordship. Lordship would see that after the observation made by your Lordship has recorded that there is no fetter imposed upon the operation of the bank accounts. Lordship, now your Lordship, if your Lordship comes to page number 172.
No, which portion are you relying? Page 162?
The second paragraph. Hence, there is no fetter imposed upon the operation of the bank account. Lordship may kindly recollect that there were two directors. There were some personal problems in between the directors.
Yes.
Lordship says that whatever problems they had, that need not trouble this. They can raise their bills in that account, whichever was there, your Lordship, and we have to disburse the money. This was in regard to the empanelment of security guards.
Very well then. No, there was a direction, bills to be furnished.
Lordship, bills to be furnished. They have furnished the bills, but
and you have to disburse the amount.
Lordship, but they have mentioned a new account number. Now, Lordship, there was no direction upon depositing the money in a new account number. Now, that is why your Lordship may kindly comes to page number 172.
No, these are independent things. I mean, disposed of by directing the petitioner to furnish bills afresh.
Lordship, bills are fresh. First bills were raised in the year of 2019. Those bills have to be submitted afresh. There has been a lot of
So you file a short affidavit then explaining your position. I'll direct them to file a short affidavit.
Lordship.
Learned counsel appearing for the alleged contemners submits that there was no willful or deliberate violation of the order of this court. Push up. Next para. Since the alleged contemner seeks to bring certain facts on record, comma, the alleged contemners are directed to file their affidavits in opposition. Each contemner affidavits in opposition within a fortnight from date. Full stop. Reply finish shall be filed within a week thereafter. The matter shall be listed on May 16, 2024 under the same heading. 16th May.
Grateful to you.
Item number 4.
Item number 4, my lord,
Take
under
your
the
print
petition, my lord.
solutions.
My lord, on the last occasion, 5th April 2024, my lord has directed me to serve the contempt petition upon the contemner, my lord. I have served that. There is a affidavit.
Good service affected?
Good service
You have
affected.
checked up?
Yes, my lord.
What is the nature of the contempt?
But contempt, my lord, kindly come to page number 21.
Not
of the
disburse the
contempt.
amount.
Disbursal of the amount.
This matter I have nothing to say, but appeal.
The appeal is appearing within first 10.
No appeal, nothing, nothing information given.
No.
No, my
Appeal will be
one or
Pay the money, then file the appeal.
I'll order of 8th February, my lord. My lord, the certified.
8th February, yes. We are now on
My lord,
23rd April.
I'm not saying anything.
No, you are filing after the contempt is filed, you are going to file an appeal.
I'll leave it.
No, don't leave it on me, Mr. I'll issue a rule.
A week's time, if not by Friday, this Friday, kindly.
Week's time, what you will?
No. We'll file.
You'll comply with the order.
No. We'll file the.
No, I won't give you any time for filing appeal.
I am only today is
No.
Tuesday, but I'm asking for Thursday. Let it be on Thursday. If within that time we do not file the appeal.
If you file the appeal, then it remains indefinite. No. What were you? I mean, what was the order?
Incentives.
Page number 21, my lord, kindly come.
These are small industries. These are small scale
Yes,
industries.
my lord.
Mr. Chakravarti, why are you
No,
choking small business in the state?
I know that, my lord.
You are choking small business.
This is
This is an incentive scheme. These people are coming for incentive
We are
schemes.
for the disbursing authority.
You are not paying. You are for the disbursing. You are for the state. You are
No,
the
no.
disbursing authority. You are the judge, jury, executioner, everything.
Lord, I was asking for 2 days, if possible, my lord.
For filing of appeal, I won't give you time. I'll issue a rule.
Yes, my lord.
Learned counsel for the alleged contemner seeks some time to file. But no, then Mr. Chakravarti, I'll give you a fortnight's time to bring an order. I'll make it clear in my. I'll give them a fortnight's time. Learned counsel for the alleged contemner seeks 2 days time to prefer an appeal against the parent order. First of next para, since till date no appeal has been filed, comma, it is evident that the appeal is sought to be filed by the alleged contemners to save their skin on the contempt application. First of, be that as it may, comma, for the sake of judicial propriety, comma, as the alleged contemners have expressed an intention to prefer an appeal, comma, leave is granted to the alleged contemners to prefer an appeal by the end of this week. Full stop. Next para. The matter shall be listed next on May 10, 2024 under the same heading. Full stop. It is made clear that in the event the alleged contemners failed to obtain an order from the appellate court after filing an appeal against the parent order, in the meantime, comma, a rule shall be issued on the contempt application against the alleged contemners. Now, I don't leave any option for myself also after this. Just point out this order.
Deeply obliged, my lord.
Affidavit of service filed to be kept under.
Item number 5. Minoti Haldar.
For the petitioner.
This for the first time,
This is
Mr.
for the
Shaman.
first time.
What is the nature of contempt?
My lord, your lordship directed, my lord, the contemner with the principal respondent authority to register my biometric device. Your lordship kindly remembers I was working as a non-registered marriage officer. A show cause was issued stating that we have committed certain wrongs. We have made a reply that has not been considered. We came before this honorable court. Your lordship was kind enough to pass an order directing them to pass a reasoned order in respect of my reply within a specified time. That was not done. Pending that, they issued another show cause notice. We came before your lordship. Your lordship was kind enough to stay that first show cause notice and directed the respondent authorities to register my biometric device so that we can continue the work of registration of marriage.
Not reactivated.
Not reactivated.
The petitioner has made out a strong prima facie case as to the petitioner has made out a strong prima facie case as to willful and deliberate violation of the order dated March 14, 2024, passed in WPO 215 of 2024, inasmuch as, contrary to the direction incorporated in the said order, directing the alleged contemner to immediately reactivate the biometric device of the petitioner by registering the same in the official portal to ensure that the petitioner can resume her functioning as CAPSE, non-official marriage registrar, such reactivation has not yet been done by the alleged contemner. Accordingly, the petitioner shall serve copies of the contempt application on the alleged contemner, serve a copy of the alleged contempt application on the alleged contemner, indicating that the matter shall be listed under the same heading on May 7, 2024, when the petitioner shall file an affidavit of service to that effect.
Grateful, Lordship.
Thank you.
Item number 6, Kamak Leathers Private Limited and others versus issue.
You're for the petition.
Well, the order in respect of which contempt is supposed to have been committed, my lord, appears on page 108. They did not have the requisite certificate, my lord, under the West Bengal Fire Services Act. My lord will be pleased to straightaway come to the operational part of your lordship's order, page 118. Paragraph 40.
Right.
Following the principles laid down in the above referred judgments, further continuance of the respondent number 5's clinical establishment would perpetuate the safety hazard to the patients housed therein, as well as the doctors and other staff functioning therefrom, apart from the other residents of the building and the owners, as well as the entire neighborhood and public at large. Kindly turn the page and come to 42. In view of the above, WPO number so-and-so is allowed on contest, thereby directing respondent number 5, that is SAS Medical Private Limited, to stop the functioning of the clinical establishment being run from the disputed property at premises number so-and-so within March 31st, 2024.
They have not done it.
They have not done it.
Still running.
Well, according to us, it is still running. My lord had been pleased to give this 1.5 months time to remove the patients. We are not being allowed entry. We are the owners of the building, so we don't know whether patients are there. But the nursing home, my lord, the clinical establishment is still running according to us.
A strong prima facie case has been made out by the petitioner to the effect that in willful and deliberate violation of the order dated February 13, 2024, passed in WPO 1853/2023, wherein the alleged contemner was directed to stop the functioning of the clinical establishment being run from the subject property at premises number 195/1, Park Street, PS Beniapukur, Kolkata 7,17,000 within March 31, 2024, the alleged contemner is still running the said clinical establishment. Accordingly, the petitioner shall serve copies of the contempt application on the alleged contemners, indicating that the matter shall next be listed on May 7, 2024, under the same heading, when the petitioner shall file an affidavit of service to that effect. Please come back, Mr. Bose. We'll consider on the next.
Court applications. Item number 7, Kamak Leathers Private
You were
Limited.
the alleged contemner in the previous matter. Press direct service on you and keep it tomorrow.
No, whether I am the contempt. How do I know?
Presumption is that you are the contemner. You will have to dispel that.
I am always at the receiving end before you.
That's good, receiving end. Yes, Mr. Bhattacharya, let us see in this matter whether you are in the.
Now, this is an application we're not seeking some extension. Your lordship has been pleased to grant.
Same matter.
Yes. No, I had mentioned the matter. The matter
No.
was also moved.
Refused. No extension. Sufficient time has been given.
I could not do the needful. There are reasons, which have been recorded. The portal was closed. I approached them. Everything is.
What portal? Close your nursing home. You are given 1.5 months for this.
Your lordship if I produce the fire license, the thing is done. So the fire department did not extend cooperation. That is what is recorded here.
Suppose I'll do this. I'll direct you to file affidavits and I'll direct this application to appear along with the contempt application on 7th.
Well, this application, I would say, is not maintainable. He's
Why
trying to open a brand new cause of action, my lord.
No.
That application has been disposed of. He wants your lordship, my lord, to change
He
your
wants,
lordship.
this is an enlargement of time application.
Yes. that
Virtually
is
under
true.
148. Virtually on the.
Very well. But my lord, let him at least make a statement whether the nursing home is still running or not, since he's here and he's made an application for extension of time.
Yes, Mr. Bhattacharya. Obviously, it is running. He's asking for an enlargement.
No, but the point is, my lord had given him 1.5 months' time in your lordship's order, my lord, to withdraw and remove all the patients who were there. If patients are still there,
Yes.
and
What
my
do you
lord,
do in that regard, Mr.
and my lord,
That this application.
and I read paragraph 40 to show that
I'll
it is a
direct this
hazard.
application to appear along with the contempt application, Mr.
Has already lapsed. He affirmed this on the 27th.
As my learned
The
junior.
time
my
has
lord-
lapsed. I've noticed that. Yes. This application was filed after that 1.5.
Yes.
No.
No,
It was found on the 27th
not
of March.
4 weeks, but 4 weeks from the date in February, my lord, has already expired.
Affirms it on 27th March. Today we are on 26th of April. 4 weeks.
No, but after order record, the petitioner in the present application has prayed for enlargement of time granted to the petitioner vide order dated February 13, 2024, passed in WPO 1853 of 2023 for stopping the clinical establishment unless due permission was obtained in the meantime. Full stop. Next para, learned senior counsel appearing for the respondents in the application vehemently opposes the same and submits that the same is not maintainable at all. Full stop. Next para, immediately preceding the present matter being taken up, comma, this court has directed the writ petitioners stroke respondents in the present application to serve a notice of contempt application filed by the respondents stroke filed by the writ petitioners stroke present respondents for willful and deliberate for alleged willful and deliberate violation of the self-same order dated February 13, 2024. Full stop.
I
Hence,
appear for the
comma,
state.
it would only be appropriate if the present application is taken up along with the contempt application on August 7, 2024.
My lord,
May
I appear for the
7,
state.
2024. Full stop. Affidavits, comma, if any, shall be exchanged in the meantime. Full stop. It is made clear that the objection as to maintainability of the present application is kept open for being decided on the next returnable date.
Grateful.
My lord, I appear for the state, my lord.
There.
And my lord, the website is working. If only they would apply. They can apply at any time, my lord.
Pardon?
My lord, I appear for the state.
Yes, Ms. Banerjee.
Yes, my lord. I'm starting my video.
Yes.
My lord, I am appearing for the state. My instructions are that maybe one day when they applied, the website wasn't working, but if they would apply and if they would show their whole page on the date of application, that is not there, my lord.
Ms. Banerjee, that's why I've directed everybody to file their affidavits in opposition. So you are
My
also
lord,
their respondents, I hope, in your application.
In my application, my lord,
He must have repeated
Has
the
to be
same
because they were
my lord, even now, if they apply, they can get it if they can.
in the principal writ petition, they are the respondents.
No, Ms. Banerjee, probably if they apply now, they may not be because the time is over as per the.
My lord, the time is over, but they did not apply within time. From what I understand, they.
Ms. Banerjee, put all of these in your opposition, please, and opposition to the enlargement application so that we can deal with all these.
My
And
lord.
please give copies of your respective oppositions and replies to the other parties as well. I mean,
My lord.
opposition, Ms. Banerjee, not only to Mr. Bhattacharya's client, but also to Mr. Bose's client, so
Yes.
that all of us can come with comprehensive arguments.
Will it be,
My
my lord,
lord.
to give short directions for affidavits in your lordship's order itself, so the matter can be disposed of once and for all.
আচ্ছা, affidavit shall be exchanged in the meantime যেখানে বললাম না, ওখানটা affidavit shall be exchanged in the meantime এর বদলে affidavits in opposition shall be filed by April 30, 2024. Full stop, reply if any shall be filed by the next returnable date.
Very grateful to my
Grateful.
My lord, the matter is returnable